Dear colleagues, everyone present here in the room, everyone watching us online, we are starting our conference. Fair courts, are we doing enough? That is a big question, and that's the question that we are going to try to answer today. My name is Natalia Sokolanko. I'm a journalist and anchor of Ukrainsky Radio. I'm going to help with our communication today, and I would like to invite our speakers of the welcome panel. This is Deputy Ambassador of Germany in Ukraine, Mr. Maximilian Rush, also Ambassador of the European Union in Ukraine, Ms. Katarina Maternova, and Mikhail Zhenakov, co-founder and executive director of the DEJURE Foundation. Please take your seats. And before I give you the floor, before giving the floor to Mr. Maximilian Rush, I want to remember one journalistic story. Back in 2010, when President Yanukovych was already starting a dictatorship in Ukraine, I was at a conference in Leipzig on freedom of speech issues. And the question was, what guarantees freedom of speech in every country participating in the conference? I spoke on behalf of Ukraine, and I said, the only guarantor of freedom of speech is journalists and civil society. The representative of Romania said is that we have a strong foreign media holding, and it was a German media holding. And the representative of Germany said that's all good, but the true guarantee of freedom of speech is courts. As a journalist, therefore, I am a big fan of courts because I do want us to uphold freedom of speech. And I have to say that the practice of German courts and the general jurisdiction courts and constitutional court also, they all work to uphold freedom of speech. And I hope that we will have the same in Ukraine, and we have a lot to do for that. Mr. Maximilian, please, let's have some introductory remarks from you. We are very thankful to you as a representative of Germany. We are thankful to the German government and the Ministry of Foreign Affairs of Germany because at this difficult time, I know that you continue supporting reforms in Ukraine. So could you please share your expectations about the judicial reform and today's event?
Thank you very much for those very kind introductory words. It's an enormous pleasure for me being here today. Thank you very much, the EU Ambassador Katarina Matanova, and of course Mikhailo for being here. Excellencies, ladies and gentlemen, I think this is an important event. I'm glad that the DEJURE can do that, and we're very happy as a German government to fund DEJURE and its important work. I think that the justice sector is one, and the reform of the justice sector is one of the most important challenges Ukraine is facing at the moment, besides this terrible war. And very frankly, I'm very much impressed and humbled, because I think for most countries it would be impossible to address such reforms whilst defending the country and defending our shared values at the same time. But the enormous strength and resilience of Ukrainians is truly impressive. And that's why I'm impressed, why I'm sure, that I'm confident that Ukraine can successfully tackle reforms in the sector of justice, whilst at the same time fighting this war. We have seen so much progress in the last couple of years. I have the pleasure of following Ukraine and politics since 7 to 8 years now, and it's quite remarkable what has been achieved. And that is important because a functioning justice sector is key. It is key for the rule of law, and not least for the stability of this country, short-term and long-term. Corruption in courts and judicial administration pose a significant risk, and effective and equal access to justice for all is crucial. And then a functioning justice sector is also key on Ukraine's path into the European Union. And certainly the advancement in EU accession will depend on progress in the justice sector and beyond that in the so-called fundamentals cluster. This is such an important prerequisite as it is specifically the justice sector which further down the road will be the one that enforces the EU acquis, the common set of laws of the European Union. And of course, this again, for the EU member states, is so important to open this door, which we of course are all willing to do. As I said, the speed on the way to EU accession so far has been incredibly quick and impressive, and I think we all congratulate Ukraine on this success. But in order to be successful and to have the final open door into the EU, you must also address those areas where reforms are difficult and run counter to the vested interests of some individuals here in Ukraine. And I think this is where we are counting on civil society to keep a watchful eye. And I think the justice sector is particularly important in that regard. Looking at today's impressive agenda, also with Her Excellency Stefanishina coming later today, I think this is an important event which hopefully brings us forward. And there's so much expertise in this room and among all others listening to us online. So I'm confident that we make valuable contributions also in this respect today. Certainly, there is more work to be done on the justice sector reform. This work will not always be easy. Actually, sometimes it will be very hard and difficult, but I'm convinced you can do it. And I think we see quite a bit of political momentum, dynamism, and political will in that regard. And I think the EU is where Ukraine belongs. So let's unite all our efforts in that regard to make progress. I thank you very much.
Dankeschön. Дякую, пане.
Thank you very much. And indeed, this is an important event. I will say that co-organizers of this event are the DEJURE Foundation, the German Department of Foreign Affairs, and our information partner is Ukrainska Pravda media outlet. And of course, our most important partner is the Armed Forces of Ukraine and other units of the Defense Forces of Ukraine, to whom we are very thankful because we are able to work thanks to them to look at the future and think how our reformed courts should work in the future and what we need to do to make them fair. And I will remind you that the QR code that you see in your broadcast, and you will see it here on the screen a bit later, all participants of this event can support the robotics systems of Da Vinci unit. And now I would like to invite Ambassador of the European Union in Ukraine, Ms. Katarina Maternova, to speak as well. Ms. Katarina, I don't know how well you are aware of Ukraine's history in terms of our justice sector, in terms of our quest for justice, but I feel that all the work that we are doing now with the support of the European Union, of individual countries in Europe and beyond, is about cleansing the Ukrainian course of Russian and Soviet influence. 1,000 years ago, we had things working just fine. We had European traditions working in Ukraine. We didn't have capital punishment, for instance. We had a very humane legislation. while the charters of the Great Duchy of Lithuania that were written in Latin and in Old Ukrainian, criminal liability was starting at the age of 14 rather than the age of 7, as in the Stalin times. How much do you agree that the current problems with courts is the consequence of Russian and Soviet occupation and corruption as a characteristic of the Russian world, so to speak? Thank you very much for the invitation. I am very happy to see you. Hello, everyone.
Dealing with Ukrainian judiciary for the last 10 years. And we'll start from that. And I fully agree with the traditions you were mentioning that go way, way back. But want to tell you that it's not only the Soviet legacy, it's the communist legacy, because I come from a country that was one of the satellites, and we had exactly the same problem. And I would even go further. I would say that when, after the fall of the Berlin Wall, our country started emancipating, I think it was well meant, but very badly informed decision of our Western partners on both sides of the Atlantic at that time, pushing us into independence of the judiciary without understanding what it's going to do. It's not only Ukraine, it's country by country. Every single country with the communist legacy had to go through this painful process because we created independent judiciaries without integrity checks, without checking competence. So you suddenly created these judicial self-governance bodies that basically put in concrete and created a medieval guild in a sense. And that was just simply, you would have had to have a lot more nuanced understanding what kind of system we were coming from, because it's the only one remaining area of the societies that is a problem, whether you look at the Western Balkans, whether you look at the new member states in the European Union, whether you look at the post-Soviet space. Country by country is the judiciary and corruption in the judiciary that is still a problem. And we have to go through processes like this country has gone through since 2019 to reform the judicial governance bodies that were installed after the fall of communism, based on well-meant but completely uninformed advice. And I think that's the span of the reforms here. I see that some people in the audience probably were still in high school when this country, after Maidan, started reforming the judiciary, and it has made a lot of progress. You had the constitutional amendment in 2016, which imposed asset declarations, one of the most successful anti-corruption measures, on the judges, as a result of which somewhere between a quarter and a third of the judiciary left because they had to go through knowledge exams and integrity checks with the asset declarations, and they left, which was an enormously good opportunity to bring new blood and new good people into the judiciary. That got, of course, stuck because then the institutions that go through the exams, etc., stopped functioning. And we've been sort of every year at it. So I think that the question mark at the end of this panel is a legitimate one. And but I do want to start with saying a lot has been done. When we started after Maidan, there were 4-tier judiciary, unclarity between the type of, cassation versus appellate jurisdictions, etc. You had the famous or rather infamous Kiev Administrative Court, and so you had a lot of bad elements, and all of that's gone. So you now have a clear-cut judiciary. We have managed to, and that's going to be one of the panels together to restart the High Council of Justice, the High Qualification Commission. Of course, there are still other aspects of the rule of law system in general to address, whether it's the bar, whether it's the notaries, whether it's the Council of Justice, the judges itself. But I want to pause for a second and look back at the reforms. There were 3 elements why this was possible. Government determination after Maidan. By government, I mean the whole sort of official Ukraine after Maidan to do something. The very, very strong pressure from the civil society and the organized civil society and the public demand, and also pressure from the international partners that were becoming stakeholders in the success of Ukrainian judicial reform and other reforms through both politically, financially, in terms of support, technical assistance, and advice. And a lot has been done. We are not there yet, and I will come to the 3 panels that you will have later in a second. But now, as my German colleague already mentioned, you now have a new element that is helping. That's the 4th element. The first 3 are still there, but you now have the EU accession process. And indeed, a functioning judiciary is one of the key elements of coming to the EU. It's part of the, I can't believe I'm using the jargon, but it's used in your media anyway, the screening of the first chapter, of the first cluster of fundamentals. And so that's helping. That's helping the process, but the tricky issue is that in all areas where there is no specific EU legislation, the famous acquis communautaire, it's much harder to get it just right. And that's why when people have a feeling that, oh, we may be getting different advice, it's true, because there is no acquis communautaire, there is no directive, there is no regulation on how a judiciary should be set up or who nominates judges. In Finland, it's the Minister of Justice. In Germany, there is a different system. You have appellate, you have cassation system, you have completely different systems. They just need to work. And while we haven't learned our own lessons all that well, we have learned in the process a number of lessons, and those are the areas that we push for and that we put into our enlargement reports, our screening reports, and into the benchmarks that Ukraine and other countries will be judged by. So let me address the three issues. Judicial governance reform, have expectations been met? As I said on this one, and you may not hear it from many people, I think that we were co-organizers of the problem, because it was our advice that led to the bodies that then had to be reformed, and we went through the same process in Slovakia. They are going through the same process in Albania. They are going through the same process in Poland. I mean, it's a country by country by country. And the judges, of course, as a protected profession, fight back because it's against the vested interests of what was created. I think we are more than halfway done. I think the reset of the High Constitutional Court was immensely important, and the High Qualification Commission, I think but we still, as I mentioned, have a couple issues to address, whether it's the bar, whether it's the Council of Judges. On the second issue, Supreme Court, we are restarting. I mean, Supreme Court was already restarted, perhaps not in an ideal way. We all know what happened afterwards. So I think this is an area where you will be hearing from us. Ukraine is hearing from us. It's part of the enlargement report. It's part of the discussions that will take place in the first chapter on first cluster on fundamentals. And it's part of the roadmap that Ukraine prepared for the fundamentals. So the determination is there. It's not going to be easy, but we'll get there. Which leads me to the third point, and that's the issue of international commissions in the selections of judges. This is a tough one. This is not an easy issue. I am aware of voices in Ukraine talking about sovereignty. I don't think that's necessarily the issue. I think that in a situation where one is dependent to the extent that Ukraine is on support by our taxpayers, by taxpayers of countries that support you, I think it's legitimate to be, in fact, taking responsibility on our side, or co-responsibility rather, for the outcome. And in fact, this was something that was very hotly debated a few years ago, and I was one of the voices in working in the European Commission at that time that we should be taking part in the selection panels for the top leadership. I don't think we should be, we shouldn't be overdoing it, but as a temporary measure, as a measure to help reset the system. And in all honesty, I was such a strong advocate of it for the very reason I mentioned at the beginning, that we were part of the initial problem. So I think while the system is still changing, I think there is a role for international partners. There are some models that are better than others. I'll leave it for the next panel, but I think I see it very much as a temporary involvement that should be phased out when the judicial system and the other bodies are fully formed. So I think that I'm watching the space and the discussions we have with the Ministry of Justice and the Rada about the High Administrative Court that's going to the Parliament this week or next, or in a couple of weeks. And I think that perhaps can be a very good model for the others. But there is a number of them, but I think the principle is co-responsibility on our side for the future of the system, and but let me stress, as a temporary measure. So I will stop here. Sorry for being a little bit more detailed, but I couldn't take part in the panel for other events that I have to go to, so I thought I would share these views. Thank you.
Дуже дякую вам, пані Катерино.
Thank you, Katerina, and specifically thank you for reminding us what European Commission is looking at, where you focus your attention on. It's very important for the representatives of the Ukrainian government, and Mikhailo Zhirnakov, co-founder and head of the DEJURE Foundation. The question is, if we imagine when the reform is completed, we have effective courts in Ukraine,
Will the DEJURE Foundation, the DEJURE Foundation will have the textbook, how to do reforms. So if we look at that textbook today, is it the middle of the textbook, or are we closer to the happy final already? Thank you, dear colleagues. Well, let me say it this way. A couple of years ago, we celebrated the anniversary of our work, and our international colleagues and other colleagues told us, well, they wished us and they said, "Lord, live de jure." So, meaning, well, they were hoping that we will cease existing, and we actually want to have the situation where there is no necessity for us to exist, so that we have the judicial system that is resilient and that doesn't need any international experts, any external experts. So that would be a resilient system that would produce better results. And I don't think we're there quite yet. And I do agree with the ambassador that, of course, this is a temporary measure. This should be temporary, but I think we'll talk a lot about it during the panel. And, well, today is definitely not the moment to decline the recipe, to say no to the recipe that is working. And I think the history will show us where we are historically. And I would really want it to happen tomorrow or next year or in 2 years or in June, when another international commission that selects members of the High Qualification Commission takes place, but I'm not sure it will happen so fast. And we've been thinking a lot about the name of the conference, the title of the conference, the title of this event, and about the contents of this event as well. Because if we look at the list of what we should do, what has to be done just only in the courts, just looking at the institutions and the areas, we have judicial administrations, judicial map, judicial expertise, completing judicial decisions, the School of Judges. So we can list a lot of things that we haven't even reached yet. And I'm not even speaking about the Supreme Court. And there are more layers that impact this. This is the prosecution aspect, the legislative education, and a lot more aspects that have to be focused on. But we decided to focus on the key things here. And I can just bring here an analogy with the point in time. I think that the moment between the first and the second panel this is where we are now. During the first panel, we will take a look at what we have done and how we did it, because I agree with Katerina that we have done a lot. We have overcome a lot, but the question is how about the quality of this. So the reform of the high qualification committee, and I do personally think that we've completed a lot, but I also think that we have to work further to complete the rest. The second panel is the key thing out of what is and has to be present in our reform agenda, in our judicial reform agenda. This is the Supreme Court, and I think we don't speak enough about it. All of us saw the problems there. All of us saw the previous selection that, well, did not happen the way it should have happened in order for the institution to function properly. And we have to focus and talk about what we should do, and that this should be a priority. And the third part, this is the overarching, right? This is the overarching part that we're going to talk about both parts and about the whole system. We're going to talk about how we did it. We're going to talk about the recipe that we finally have. And I do share the views that Katerina presented, and that there is no recipe, clear-cut recipe that would external recipe that would say do this way or do that way. Unfortunately, we had some negative things as well as a result of copy-pasting some models from the other countries as they have them now. But finally, thank God, we found the recipe that is working in Ukraine, that gives the result. And today in the room, we have the representatives of the bodies, and I'm very happy that we have them here, the representatives that have been selected based on the new procedure with international experts, and they are producing the results that we could only dream about a couple of years ago. So, of course, we would like to talk about it, and I'm hoping that we will talk about it during the third panel. We'll talk about how to preserve this. If we want to reform things, if we want to achieve results, Of course, this international experts, they don't have to be permanent there, because how can we be part of the European Union if somebody else is selecting judges and we cannot do it by ourselves? But in order to reach that point, we need the instrument, we need to preserve and strengthen the interest that we have. And as the Venice Commission says in its recommendation about it, when it gives the result, only then can we talk about refusing this instrument. So I'm very grateful to everyone. I'm very grateful to the representatives of the German government. Your Excellency, the Ambassador of the European Union, thank you. Thank you to all the colleagues who support us. Thank you to all the diplomats, to the civil society organizations, to the government agencies that are working on this quite challenging task. And I'm very grateful. Max has mentioned before the role of the civil society organizations. And I would say, despite everything that is happening right now, we will keep working. We will find the resources. We will find the strength. We will add even more of our resources if we fail to find external resources. I'm very grateful to the German government, to the European Union for the support, for the financial support. I'm very grateful for the fantastic result that we have right now. And I'm personally grateful to the ambassador for your role in it, because without it, this locomotive, this opportunity wouldn't be there, this opportunity to complete these crucial things that we have to achieve. But whether we are doing enough, well, let's try to answer this question during these 3 panels, during our discussions. Thanks a lot to everyone again, and have a good, fruitful work today. Thank you, Mikhailo, and thank you to all the participants of our panel. You're welcome to take your seats in the room, and right now, we are about to start our first discussion panel, the updated judicial governance. Did the hopes come true? And I would like to welcome our speakers to join me on the stage. Anton Zelinsky, Advocacy Manager of DEJURE Foundation. I would like to welcome the Deputy Head of the High Qualification Commission of Judges of Ukraine, Oleksiy Omelyan. Member of the High Qualification Commission of Judges, Roman Sebodash, and Oleg Yakimyak, a co-coordinator of the Public Integrity Council, and Christina Burtnik, senior lawyer of the DEJURE Foundation, Oksana Kvasha, member of the High Council of Justice. Dear speakers, you're welcome to take your seats here. And let me just tell you that online, there will be Alexander Yapchenko joining us, Ukrainian military and civil society activist. I think I mentioned everyone here. Did I not leave anyone out?
So we are going to start our discussion about the updates in the judicial governance bodies, how much more influential, reputable they have become in Ukrainian society, in the judicial sector. And we are going to start with a presentation of a study dedicated to this. Anton Zelinsky, Advocacy Manager of the DEJURE Foundation, is going to speak about this, and then we will respond to this. Thank you. The qualification assessment of judges was meant to cleanse the judiciary after the events of the Revolution of Dignity, when representatives of the judicial system were following Yanukovych's orders. They were depriving the participants of protests of the right to drive, driver's license, or even arrested them. In order to cleanse the judiciary, the High Qualification Commission of Judges was created, and the Public Integrity Council was created to assist it. And these 2 institutions were meant to cleanse the judicial core in the course of their work. During the first few years, the activity of the Public Integrity Council was studied quite well. I was an analyst for the first and second compositions of the council. Now I am myself a member of the third composition of the Public Integrity Council since 2023, and I had this idea to sort of take a cross-section, take a snapshot of how it works in this new version with the new composition. During 2016 and 2019, the qualification assessment was reformed for almost 2,500 judges, but only 4% of them were recommended for dismissal. And as a result, we actually have a situation when the High Council of Justice dismissed only 0.6 or 15 judges of everyone. Who was assessed, so the results were almost zero. This process did not perform as expected. Now, with the new composition, during the first 9 months, 121 judges underwent the qualification assessment, and 1 in 5 judges were recommended for dismissal. Today, the High Council of Justice has already dismissed 6 judges, so we see that quantitative scores have developed into qualitative. If we look at what is more important, quantity or quality, quality is of course more important, since those judges who were unable to administer justice have almost completed this assessment, and those who are still in wait can work now. So the duration of this assessment does not affect the workload of a judge, and this process can be done only once, so we can do the analysis in a quality way, even if it is slow. As for the work of the Public Integrity Council, over the first 9 months, the Council sent almost 200 opinions to the Commission. As of August 2024, the HQCJ agreed only with a third of these opinions, but over the past half a year, we see a growth of 8% to 44%, and therefore we see that the positions of the PIC and the HQCJ are getting closer. Which means that we are getting common understanding of what a judge's integrity should look like. An interesting aspect of this study was the analysis of results of the anonymous written testing. During the previous composition of the HQ CJ, almost 100% of judges completed it successfully. So it didn't allow us to understand their qualification level, actually. The test assignments changed, their number increased, which made it impossible for judges to learn them by heart. And now we see that actually, according to the new results, 1 in 10 judges failed to prove their competence, which means that this procedure became effective rather than just purely formal. Interesting. Got a blue screen here. Can somebody please help us? I can speak without the presentation. Yeah, I think we can continue a bit, and you will just follow up when the presentation appears. Yes, please continue. So the main problem of the qualification assessment in this period is the avoidance of this assessment by judges. That is, judges file applications to resign, and they essentially resign with major pensions, with major payments, and Slic24 provide information that about 5 billion hryvnias is spent every year to pay the judges who are retired. How do judges avoid this assessment? Back in 2019, the notorious judge Vovk recommended his colleagues from the DACK not to come to the to obtain the results of their assessment. This practice became so popular that in 2023 they had to amend legislation and grant the commission the right to carry out assessment if a judge fails to show up to the assessment 3 times. Unfortunately, we see that Maidan judges actually never went through the qualification assessment. The High Council of Justice granted them the right to resign, particularly due to their trick when they dragged out their assessment due to a sick leave. So a judge would go on medical leave, then come back and issue 20 or 30 decisions a day, and thus judges actually were delaying their assessment during 9 or 10 months. Also, the infamous decision of the Grand Chamber of the Supreme Court in the Usate case was actually also quite problematic because it essentially annihilated the negative opinions of 180 judges by the Public Integrity Council in its previous composition. The High Council of Justice also doesn't necessarily consider these claims for dismissal quickly, and we have a remarkable example of Judge Hanna Andrienko, who closed about 50 cases of driving under the influence. She issued decisions with backdating in a few cases, so it was essentially forgery. The High Qualification Commission of Judges recommended dismissal of this judge, but this issue was taking a long time to review. In the meantime, the judge got the support of the Grand Chamber of the Supreme Court, and they forced the HCJ to consider her resignation, and she was able to retire with all the benefits. Interestingly, they were reviewing 2 things at the same time, and when the first issue, which was less beneficial for the judge, was considered, the judge suddenly got sick again. And then the Public Integrity Council actually interfered with this. When we have the reformed agencies that indeed started cleansing the judiciary, as a result, all this mechanism breaks down due to the Supreme Court. Even looking at this study, which was written in August 2024, I'm quite optimistic about the future, since a lot of recommendations that were mentioned there by the were completed by the PIC and the HQCJ. In particular, they resolved the issue of anonymous written testing. The Commission also ensured proper access of the PIC to judges' profiles and took a lot of other steps that influence the quality of assessment. Unfortunately, we still don't see this openness with practical tasks. Also, the PIC doesn't have access to declarations of judges, their declarations of family ties and declarations of integrity. In its turn, the PIC received more access to registers and receive a procedure for personal data processing. As for the speed of the qualification assessment, the PIC and the HQCJ are working on the speed. They worked on this during the strategic session. They are developing mechanisms, tools, and how effective they are, we will be able to see during the big competitive recruitment for the judges of appellate courts. I think that this snapshot and this work will be very interesting because this is actually the situation with the qualification assessment that exists today, and I hope that this will be just one step to cleanse the judiciary. Thank you. Does everyone else see this the same way? Particularly, I want to ask the Deputy Head of the High Qualification Commission of Judges, Alexey Omelian. Hello, dear ladies and gentlemen. First of all, I would like to thank you for the opportunity to participate in this event, for the work that the defense forces are doing for us to have this opportunity, to partners who are clearly very aware of the difficulties that we have in our work, in the work of commissions and other agencies, and the challenges that we have during this time. As for the answers to your question, Anton, I want to say that democracy is actually beneficial precisely because there is an opportunity to have different opinions about the same events. And obviously, this can be measured, the level of democracy can be measured by this pluralism. So it's wonderful that we have an opportunity to assess these things, to analyze them, that we can convey these ideas. We hear each other better now, and we are looking for effective, smart decisions. Okay, let me invite member of HQCJ Roman Sabadash about the presentation, about what he heard. Okay, then when it comes to the reservation that was expressed, I would disagree with Anton in terms of saying that all those 180 judges who were let off by the Grand Chamber of the Supreme Court were necessarily of low integrity. I think that was a somewhat rushed statement. Let's complete their qualification assessment, and then we will see if they meet the criteria of integrity and professional ethics. The Commission does not always agree with the Public Integrity Council. Sometimes the Commission does disagree, and the Commission tries to explain it in detail in its decisions. We do a lot, I think, to ensure that our decisions are justified so that an outside observer can understand why the Commission made a certain decision for this or that reason. As for the study, I completely support the position that such snapshots, such analyses of activities of any agency are necessary because they enable us to see the results of our work. So these are the two components that are part of any process. This also allows you to see from outside how you're working, what you're doing, and this gives you an opportunity to fix your errors, to fix the work of your agency, and maybe coordinate better with the Public Integrity Council, which also supports the Commission sometimes and also amends its opinions in line with ours. So a dialogue is always beneficial, I think. I have a question to you as representatives of the high qualification of judges. The current composition, I think, is mostly represented not by judges, right? Yes, now we don't have the 16th member who should be appointed from among judges or retired judges. How does it affect the situation? How much more principled you would say the HQCJ is when reviewing the opinions of the PIC compared to if this agency consisted mostly of judges? Do you think there would be more pressure overall? How does the High Qualification Commission of Judges overcome pressure, if any? Look, I wouldn't ask the question in that form. Like there is a certain conflict between members who are judges and members who aren't. All members of the Commission have been selected the same way. All members of the Commission clearly understand their role, the reality in which we live. At the same time, I want to say that The Commission is a democratic agency, and the majority of decisions, particularly the ones that will create case law in this area, they are made by the majority of vote. That is the point of a collegiate agency. As for whether we need the 16th member, obviously we do. We definitely need people because this will improve the quality and speed of our work. And now, using the opportunity, I would like to urge those present in this room and those who are watching us to promote what the Commission is doing now, which is recruitment of judges, selection of judges. This is the new blood that the representatives of civil society and our partners spoke about. Now the situation is unique in terms of the number of available positions. This work needs to be done. We are looking for judges who are professional, who have high integrity, improve the mechanisms and tools that we use for the selection. Roman and I came here from Kharkiv today. We had personal meetings with candidates, and I asked everyone who has this opportunity to encourage potential candidates to participate in the selection. I cannot say that I can justifiably comment on any kind of pressure, but I do think that we don't have this conflict or this division between judges and non-judges. I didn't mean that there is a conflict. I meant more like objective or not objective reality, but I think what we observed in the first composition of the PIC and the previous composition of the HQCJ, I feel there were certain tensions, there was certain pressure when the large judiciary was pressuring the small HQCJ. If you ask me as a commission member, I personally don't feel this kind of pressure, and I don't see it in terms of the commission's work overall. I wouldn't say that I observed some kind of pressure let's say, on myself or other non-judge members by members who are representatives of the judiciary, because we make decisions after long negotiations, so it doesn't matter what part of the quota you represent. Thank you. And Anton wants to respond. I think I do have an answer to this question, and the answer is how the composition of the previous HQCJ and this one were formed. In the previous one, there was nomination, and there could be some expectations related to that, but the current composition of the HQCJ was selected at the open call, and I think that makes it harder to come up with some expectations, obligations. So whether they are judges or not, I think they can look at candidates in a fair manner. I think this is a historic moment. A representative of the Public Integrity Council is defending the High Qualification Commission of Judges. I think this is a big accomplishment. As a co-coordinator of the Public Integrity Council, I think you have a unique experience of working with different compositions of the PIC, with the previous composition of the HQCJ and the current composition. So in your opinion, how has this update of judicial governance agencies happened? How much impact has it had? Because the question of our conference is, are we doing enough? So how do you feel about that?
Thank you, Natalka. Natalia, in fact, is well, unique persona because she's a participant of the first compositions of PIC, and we can actually clearly understand this difference that we observe and we can understand where these differences come from. In particular, when we look at the way how people were selected to the HQCJ, and we can also look at the result we're working with. And that's why we have a dialogue with the Commission. PIC and the Commission, and I think we also have cooperation, and we have the experience of responding to certain risks, and I think this is the precondition for growth, for improvement as well, going through some crisis together, and the ability to find the solutions that allow us to grow further. And if we look at whether our hopes came true, I'd say yes and no, and that we are on our way. We are still in the process. Speaking of hopes, the hopes can be very different. A lot of hopes did come true, in particular my hopes, and I see this difference. I see the results that, well, we formulated them at the tasks of PIC and HQCJ and even High Council of Justice. So the judiciary is changing. Well, maybe not so fast and in not such a pretty way, but the fact is that the changes are happening. And of course, we would like to have this instant result, instant solution, like, like Nescafe coffee, you just make it and drink it immediately, you see the result. But the process is more difficult because, as it has been mentioned, there are a lot of layers that have their impact and impact the effects, the results that we want to have. And we want to have a just court. All of us want it, and well, not all of us at the same time. We are in the environment that impacts all the bodies of the government, and in particular, it has its impact on the judicial system. And I witnessed a conversation of, well, a person, two people, and the essence of the conversation basically was about the court case. And one person said, why do I need a court that does not make decisions in my favor? But there is a request of the society. Well, not a total request, but there is a request like that. And the judicial bodies either respond or don't respond to that request. In order for them not to respond to it, we put systems in place, systems of influence, and in particular, so that there is, let's put it this way, a fear of punishment. And that was mentioned, the honorable retirement that the judges have without actually deserving it. This presents discomfort to other judges, and it creates this unjust feeling, the feeling of injustice when for other people who observe it. And there is another moment of this high pension, right? And this moment of protection and respect from the society, the respect towards the judge, even the judge who is retired. And it should stimulate the person to be honest and to try to be in line with all the rules that are in place for this position. And maybe, well, first of all, there should be moral and ethical background, because a person should be in line with some moral values to decline certain suggestions that are not in line with the law. And while the punishment, in my opinion, has a couple of functions. If we look at the judge who is engaged in illegal practices, first of all, the fear of punishment kind of keeps the judge in the tone and prompts the judge to remember about the moral values and to not engage in illegal activities. There is also the moment of reevaluation of certain things by a judge that some time ago were considered as a norm by the person, or, well, the judge whether changes or doesn't change the behavior. And if they don't change the behavior, there is still the punishment that should be in place. And the punishment should be to let go of such a judge. And I would like to draw your attention to the following fact. Since I represent the institutionalized body, the institutionalized public body that is in a way integrated into the judicial governance system, well, so in one part it's there, and in the other part it also has the societal involvement, so it has the opportunity to have this bilateral communication. It has the opportunity to look at the request from the society and to look at the judicial government. So this makes it clear as to which steps should be taken, because the judges are the elite that should be, well, a little bit higher in terms of moral and in terms of the intellectual abilities, and they should actually assume the leadership role. And this is what I want the situation to look like. Thank you, Oleg. And then let's move on to another presentation. Christina Bortnek, senior lawyer of the DEJURE Foundation. Christina, over to you. Thank you. First of all, I would like to start with saying that over this year, we saw a lot of improvements in terms of High Council of Justice in their work. There was a fundamental work done to establish the service of disciplinary inspector, a body that would support the High Council of Justice to prepare the conclusions to consider disciplinary cases. And we noticed that, of course, there are exceptions, but in the majority of cases, the consideration of the case of to let go of a judge is stopped when there is a complaint that can lead to the dismissal of a judge. Also, this year, High Council of Justice considered a lot of priority cases, the cases of judges who supported the Russian aggression, judges who collaborated with Russia, and judges with Russian citizenship. So in these cases, the High Council of Justice had quite quickly considered such cases. And the other category of cases are the judges that are suspected of or accused of receiving illicit benefits, so that are basically caught receiving a bribe. And the practice is quite clear here. These judges are being let go of. And this year, the High Council of Justice started a lot of cases against district administrative courts of Kiev, and there are some decisions there. These decisions are not final yet. They are being considered at the High Council of Justice, but for the society, this is a good sign that there are positive changes happening. And we held research of how the High Council of Judges considered disciplinary cases, and our goal was to have a look at the person huge, 21,000 for 15 members. This is an immense number, and it's very hard to consider during this period that is given by the legislation. And there are a lot of complaints that have accumulated during the time when the High Council of Justice did not carry out its disciplinary function. So the key task of the High Council of Justice was to prioritize the complaints in a way that they don't get stuck in the large number of unsubstantiated and small complaints, and instead so that they focus on the complaints that are important and that have to be considered first of all. And if we look at the statistics, we have 48% cases considered, so that's 10,000, and it is a large number for 15 members of the council. But if we look in more detail at this number, out of 10,000, 9,500 are the complaints that were returned back to the complainants for many reasons. Maybe the person didn't sign the complaint, maybe the complaint was not substantiated, or maybe it was anonymous, or any other reasons. But this number is a very large number. So 9,500 complaints were returned. And so the cases that were considered, there are not a lot of cases that were considered. And what's more impressive is that over a year, 117 judges were held accountable, but this is just 1.2% of the complaints considered. So all these number of cases that were considered by the council, we see just that a very small percentage of the cases led to the punishment of the judge. And it includes various types of punishment, such as dismissal and disciplinary action, etc. And we can see that the members of the High Council of Justice that used to be judges before, they impose less rigid punishment and are inclined to hold the judges accountable less. Now you understand why I asked you about the pressure of the judicial system. The indicators on each member of the council are very different. The smallest number is 1 judge held accountable, and the biggest number is 23 judges accountable. So we see that each member of the council had various numbers of judges held accountable for their actions. And moving on to our recommendations, what can be done? First of all is to focus on the priority complaints. So here, as I explained before, a lot of complaints were not considered, and probably some members of the council looked at the current cases, current complaints. For example, complaints are related to the judges who have already been dismissed, instead of focusing on more urgent cases. And in our research, we focus on very specific examples when a member of the High Council of Justice has very urgent, pressing cases to be considered but have not been considered yet. Another point is looking at the grounds to decline opening the case. And if the complaint is left without consideration, you can send the complaint again. But when there was a decline, when the complaint was declined, it means that the analysis has been held and there was no ground for the complaint. So maybe these two aspects have to be more clearly specified in the legislation. And another point that we would like to suggest is that the complainants should have the right to argue the decision without the agreement of these chambers and of the members, so that in any case the complainant has the right to argue the decision if they believe the decision was not the one it should have been. And another recommendation is introduce a point to the legislation, a provision to the legislation, so that the High Council of Justice members cannot consider the complaints related to the court where they used to work. Because we understand there could have been personal moments there, but even if there is no conflict of interest, if the member of the High Council of Justice worked in that court before, they might be interested in the positive result for a particular judge. So maybe this is something that this provision has to be introduced into the legislation. And the last one is a more general recommendation that we suggest. We suggest expanding the checks for the candidates for High Council of Justice, so the competencies also should be checked in addition to integrity. And when I say competences, I mean knowledge and the ability to consider the disciplinary cases. And maybe I will stop here. Thank you. Thank you. Yes, I think we've learned a lot, and Anton would like to respond, right? Yes. If you don't mind, I have a small announcement to make. Each of you has a folder, and you have the research there, and the research that has just been described by Christina. So please take a look, share your impressions. Christina, thank you. And now I would like a member of the High Council of Justice, Oksana Kvasha, to respond to the recommendation and to the statistics presented. So the fact that 1.2% of judges were let go as a result of these cases, of the complaints that were considered, is this number enough? Or, in your opinion, this is the reality that we get? So the dismissal of judges. So maybe you're looking at the annual statistics. First of all, when I heard, as Mr. Zhenakov said, about the results that we could have only dreamt of a couple of years ago, I was happy. But then Mr. Zelinsky criticized it, and then Christina, as every woman, selected this golden in the middle. She looked at overall. And when it comes to the disciplinary liability, in fact, we have 15 members of High Council of Justice who consider the cases. And trust me, this amount of work that was divided off as of 1st November, there was a large amount of cases. So we had about 700 cases the day I had 700 cases the day I started work. And when the disciplinary service started working, the service is facing the same issues that we faced, and I don't think it has become easier for us. It has become more difficult because there's a problem of communication, independence, etc. And when it comes to the statistics presented by Christina, well, the information that I have from the Secretariat from November 1st, 2023 until February 1st this year, 147 judges were held accountable and 53 judges. There were documents submitted to dismiss the judge from the post. And I don't think it's a small indicator. And I think as the indicator gets lower, it means that the judicial branch of power is in line with the request of the Society for Justice. So I know that, of course, everybody works in different ways, and I think that the High Council of Justice does a lot so that the judicial branch is in line with the professional demands, with the requirements of integrity, transparency, accountability to the society, and disciplinary liability is one of the legal means to implement this accountability. So, in fact, the chambers were formed in a way so that the majority are the judges. And in High Council of Justice, we have 10 judges and 7 people who are not judges. This is the requirement of the law, so I will not comment on that. But what I'd like to say, I would not divide High Council of Justice member based on how they work. I was the last one to have joined the council. We have 4 open positions and we will have 2 more. And I see that there are members of the High Council of Justice who, irrespective of the fact whether they are judges or not, they might have different approaches to work. And, this is inevitable for everybody every agency that works as a team. So everybody asks themselves, why have I joined the body? What's my goal? And what...
Таке питання ви поставили суддівського рядування.
So I asked the question, is the mission impossible to update the judicial governance? I do think that this mission is possible. Well, that's good news because honestly, I wouldn't want to think that this mission is impossible. Yeah, I think this mission is very realistic, and I'm confident that all agencies that strive for a fair court. I think Ukrainian citizens go to the court sort of as a last resort. This is like sort of like a church. This is the last instance where you ask for protection. There is this well-known phrase that says that there are only three professions in the world whose representatives wear robes: priests, judges, and teachers, scholars, I mean. So the mission is definitely possible. Nothing works fast. I actually think that if something is done fast, it cannot be good, it cannot be high quality. And I think we are doing everything to ensure a cleansing of low integrity judges, but at the same time, there are enough judges who work conscientiously, who risk their lives in frontline areas. They remain there. They give hope to citizens that their violated rights will be restored, and they stay there until we relocate them. Yes, we are absolutely thankful to those judges who are working under Russian shelling. I have a question about recommendations that Christina mentioned. How do you feel about these recommendations, and how do you feel about this very rigid opinion of the head of the DEJURE Foundation that judges who visited the occupied territories haven't been dismissed and so on? Personally, I cannot speak for the entire agency in those terms. If Mr. Znakov is really categorical here, I support him, because when we were adopting the unified indicators of integrity and professional ethics of judges, I was consistently supporting the indicator that attendance of the occupied territories including Crimea after 2014, without an urgent need, cannot attest to a high mission. I like the word mission today. See, I keep using it, of a person wearing the judicial robe. We look at many cases like this. For example, I was surprised when I joined this agency from the academia that indeed quite a lot of candidates for the positions of judges visited the occupied territories. But in many cases, they did have good reasons for this, and we cannot disregard that, because it is not necessarily for leisure or entertainment. And they are sort of saying Crimea is Ukraine, so we went to Ukraine, and they say, would you go there now? So I think this indicator is very important. And if somebody was tracking these indicators, this is the most difficult one that we adopted with a lot of discussion. But I personally don't have any doubts about this, because during the war, Ukraine cannot afford to turn a blind eye to people who want to wear the judicial robe, but don't have enough love for their country, don't have enough understanding of the dangers. I'm confident that patriotism is something that characterizes true citizens during the war, especially judges. Alexei, you wanted to respond? Yes, thank you for noticing that I grabbed the mic without the protocol a little bit. I want to share my thoughts as a judge here. Speaking of justice, we shouldn't forget that judges are people, members of civil society like anyone else. They have families, they have loved ones, and most judges completely understand the situation. And also, all these people have the same demand for justice, be it the qualification assessment, be it disciplinary liability. We are speaking about European integration now, right? About values that we strive for. And one of European values is individualization of punishment. Every situation and the issue of qualification assessment, of disciplinary liability, and so on, has to receive its own individual judgment. And this statistical principle sort of removes this idea of individuality, and it prevents us from understanding these processes in depth. So I would be a bit more careful about this. I understand your position, though it's hard to understand how we can measure effectiveness otherwise. Now we have with us Alexander Yapchenko. Hi, Alexander, do you hear us? Yes, hello everyone. Glory to Ukraine. Glory to the heroes. Alexander Yapchenko, for those who doesn't know him, was one of the drivers of this big reform process that started back during the Maidan times, and activists were planning the most urgent reforms and identified the judicial reform as one of the top 7 reforms that had to be carried out. It has been quite a while, and I think the most important thing here is that we were able to accomplish a different procedure of formation of judicial governance agencies, which was the problem of that first attempt after the Revolution of Dignity, because we entered this reform with an unreformed HQCJ and an unreformed HCJ. Now there are the people working on the reform, but I am curious about your assessment, Alexander. How do you feel about the report presented by our colleagues from DEJURE about the work of the updated judicial governance agencies? And overall, how do you feel about all of this from the front line? Can you see successes in this change towards a fair court, or not quite? I guess I will look at a bit bigger retrospect, because I want to assess things in a fair way, and we need to assess something. We have to compare it against something else. So I'm comparing what is happening in the judiciary now with what was happening in the system of injustice that emerged during the Yanukovych times. Undoubtedly, what was happening then, well, we have this enormous precipice between the two. We couldn't even dream about something like this in 2012, for instance. So when I look at this in this retrospect, I think our war for independence started back then on Maidan at the Revolution of Dignity. And now we are still trying to distance ourselves from the systems that Yanukovych almost succeeded in installing. We basically almost gave up all our influence. We submitted to the influence of the Russian Empire, which, or not quite empire, I don't know, what should I call it. But the idea is that there was no justice there, not even remotely. And now I will speak about the feelings of the military. We know that a small Soviet army cannot win against a big Soviet army, which Russian army actually is, with this complete disregard for human life. We see this, I wouldn't say every day, okay, but at least a few times a week we see how they shoot each other, not because they are brave, but because they don't have an opportunity to backtrack, to withdraw. So this is a country that ignores a person's right to life, not even speaking about things like the right to dignity, the right to freedom. So the country that attacked us wants us to be the same. It wants us to have the same system that they have. However, we are trying to fight against it in every way possible. And instead of the statement that a small Soviet army cannot win against a big Soviet army, I will say that a small totalitarian country cannot win against a big totalitarian country. A small country of injustice, of lawfulness, cannot win against a large country of injustice. So we need to do everything possible to become less and less of a post-Soviet army. We have to make every effort to become less and less post-totalitarian country, to remove ourselves from the Soviet influence. The USSR existed not very long ago in historical terms. And I don't undervalue all these generations that did this before, but we started fighting for independence after the Revolution of Dignity. That's when we took the first steps on the path that we are now moving on. We are making effort in the front and in the rear to turn into a country that I am confident many Ukrainians dream of, a country with rule of law, particularly with inevitable punishment for corrupt officials, for other criminals. So I'm really very thankful to you for your work. I am a very big supporter of your work, because I know that the idea that people from the front line will get everything done is a belief of immature citizens, because citizens who support their country are already supporting it today. And I'm very thankful that you are citizens who are working towards the good of the country. Thank you very much, Alexander, for finding the time to join us. Thank you for everything that you have been and are doing for us all, giving us the opportunity to live, to work, particularly to work on the reform of the justice system. The one thing I wanted to add is not just about the inevitability of punishment, but also inevitability of disciplinary liability of judges who deserve it, which is more in the context of our conversation. That's punishment too. Okay, that is also punishment. I just wanted to sort of go a bit more into detail. Anton wants to say something about this. It's not a response. I want to ask Oksana a question, since I am responsible for criticism here. I hope this will be constructive. Even though the Grand Chamber of the Supreme Court interferes, unfortunately, with the powers of the HQCJ and the HCJ, you mentioned that from the 1st of November to the 1st of February, there were judges dismissed under disciplinary complaints. In my presentation, I had the figure that in 2024, 40 judges applied for resignation, and thus they avoided punishment. Today, we have 45 applications about request for dismissal filed by HQCJ, and there were still not enough dismissals made. Why is there this discrepancy between the number of requests for dismissal and actual dismissals? Why isn't this a priority for the High Council of Justice? I understand that you cannot account for the entire agency, but what is your personal opinion about this? My position about the things that you are talking about the Grand Chamber that allegedly interferes in our work, legislation says that if a judge who wants to resign can do this without a qualification assessment unless there are complaints and unless a judge has committed a significant disciplinary violation. The priority is established by legislation, Article 42 of the law on the High Council of Justice, if I'm not wrong. And there are several components there, and you mentioned only one of them. The HCJ maintains this order of priority as much as possible. I don't know if you can notice this from outside. But if we speak about things like extra procedural communication, that is a major disciplinary violation that is considered by the High Anti-Corruption Court. And if you watch our meetings, you will see that these are two very different types of liability and two proceedings that have to take place at the same time. There is a different position. Let's wait for the court verdict and then we'll have the reason to dismiss this judge. But we say no, this may take years, as we have already seen. And the case in court may indeed go on for a long time. If we have a priority case, we consider them. You mentioned the District Administrative Court judges. You probably heard how Judge Ablov was dismissed from his position. There is a big demand in society to dismiss judges who drive under the influence. Very often we have this. There is a car, there is a drunk judge, and there is no driver somehow. And when members of the HCJ are accused of not bringing somebody to liability, we have our own standard of proof. Sometimes even one picture of a judge who is in Crimea, and I want to find the truth, but there is really not enough evidence to bring one judge to liability in a fair way. We do a lot of work, but we are not an investigation agency, and sometimes our requests to the Security Service of Ukraine, to the Border Service, they are unsuccessful. This is a very painstaking work. Bringing collaborationists to liability is also a big priority sector for us. You only speak about these negative things, but if we look at this official priority, you will see that we are doing quite a lot of work. And I wanted to point out yet another problem, which the HCJ holds quite a strong position on. When judges are brought to disciplinary liability and the chamber makes the decision to file for their dismissal, very often judges suddenly remember that they should protect their motherland and they enlist in the military. I have colleagues who went to defend their country from the first days of the full-scale war. And of course, when we see such cases, since we have our own discretion, judges and lawyers do make these requests. I send questions to the military units. Why did you draft a judge? And what is more, a woman? She is not. She should not be drafted. She's not eligible. But trust me, this is a very case-by-case situation because we need to look at circumstances that are very individual. And there are suspicions and doubts when we see this military enlistment. We also try to stop that. So I agree with my colleagues that we cannot speak about percentages in this manner. There are several categories of priority cases with decisions that have to be made and fair decisions made, I hope. So I don't know if I will have the opportunity to speak more. We actually have to wrap up already. I just want to also refer to the representatives of the Public Integrity Council and our civil society organizations. You see, our agencies that are represented here, the HQCJ and the HCJ, like all citizens, they want to accomplish justice. So for me, it is always very unpleasant when you don't see how we sit at meetings the entire evening to see a case through. And when you make the decision that you feel is right, regardless of what kind of decision it is, whether it's positive or negative, whether it's seen positively or negatively, this is largely unnoticed, right?
Це мелочі.
So yes, if something was done well, oh, okay, it should be that way. But if something was wrong, we see what happens. But again, with time, we will take a look at who's right, who's wrong. But anyway, this is very harsh because as each child, the same way, each collective body cannot exist only under criticism. When there are positive decisions and just decisions, and there are a lot of them, we should understand how hard it is to reach this and how much pushback we're facing from the old system and how we're striving to carry on that mission to update the judicial governments. Okay, Anton, but very quickly, maybe blitz questions. Yes, I would just like to clarify the second part. There are 45 submissions to dismiss from judges from HQCJ. So why does it take so long to consider those appeals? Well, I don't know about other members of the council, but when it comes to me, I have a couple of appeals like that, and one is already about to be considered by the council, and I'm also considering the second and third appeals. And how did I prioritize these documents? We also had the discussed the dismissal of Ablov. We also discussed the liability of judges who helped people avoid draft to the army. And trust me, each case like that is a couple of months of work. So I can talk about myself only. So I'm trying to allocate the work in a way that I can understand how to proceed, because among the priority cases, there are also cases that have more priority. So this is how I proceeded. Thank you, Oksana. And when it comes to the news about Ablov, has been a major news. It was a positive news, and we're waiting for the final decision. And maybe we will celebrate it well with a firework. Well, we cannot have fireworks now, but we will think about a way to celebrate and to say thank you to the council for this decision. And Roman has something to say, yes, about the resignation. So my request is like this. We use this word a lot, the word resigning. When you talk about numbers, it creates the feeling that this is something bad, but this is also a thank you to a judge for a long work. And yes, it's also, if we look at the workload, I have one request. Do not annihilate the right to resign and do not equate it to something bad, because this relates to all judges, those judges who worked a lot as well, who have passed the qualification assessment. And this is also about those judges we never had any questions to. I do understand the reservations of the civil society why this question is posed, but I'd like to say that resigning as such is nothing bad, and this is the normal phenomenon. This is what I wanted to comment on. Yes, but maybe very shortly, who would like to have lifelong judge support? Welcome to join the selection, become a judge. Well, I think we all heard the appeal, and dear colleagues, unfortunately we started the panel a bit later and we don't have enough time for Q&As, but I'll share a secret that during the break each of you can approach everyone, especially the members of the High Qualification Commission of Judges, and you can talk about the selection of judges. This is the wonderful opportunity, but so far thank you to all the panelists. We're moving toward the break, and in about 15 minutes we will keep talking about the next topic during the panel discussion. Thank you. to work. I'm going to give the floor to our next facilitator. He's a person who can consult you on the state, on the judicial system. You can ask him where the hopes did come true or not. So he's like a separate institution. He is an investigatory journalist. Hilary Shabayev, over to you. Thank you, Natalia. Welcome, everyone. Welcome at our second panel that is going to be focused on the reform of the Supreme Court. What did not happen in 2016-17, and if there's an opportunity for it to take place now or in the future, this is what we're going to talk about. We're going to be discussing with our expert that I am asking to join me here. And we're about to start the conversation. The first expert is Viktor Dobovik, Director General of the Directorate on Political and Legal Issues of the President's Office. Also would like to welcome Mikhailo Zhernakov, head of the DEJURE Foundation. Welcome. I would also like to invite Josh Collier, the Secretary of the Embassy of the UK, second political secretary. You're welcome to join us. And another panelist is Dmytro Gudyma, judge of the Supreme Court. Dmytro, you're welcome to join us. And we're going to wait for the lawyer and human rights activist Masina Yem. And I think that we can start with our discussion. We can start with our panel, but I would like to start it with the presentation. The presentation prepared by Mikhailo Zhernakov, Executive Director of the DEJURE Foundation. It's going to be on the Supreme Court. It will cover what we did not manage to do back then and what has to be done now for the Supreme Court to work and to become this foundation for everyone who is trying, and support for everyone who's trying to find justice in life. Let's put it this way. So over to you, Mikhailo. Thank you, Hilary. Thank you to everyone who's here with us, to everyone who's joining us online. I know a lot of people are joining online. This is what I've been told. During the preparation, we've learned that this is the preferred format, the hybrid one. And dear friends, the Supreme Court, well, is our priority number one, the priority of the DEJURE Foundation. And that is why we're talking about it now. And this is also the we really would like it to be the priority of the country, especially when it comes to the justice reform, because no institution among the courts is more important than the Supreme Court. And this is the institution that directly impacts our rights and justice, what has been mentioned in the first panel as well. And it is also something that impacts our economic environment, and it impacts our ability to fight the enemy, and it impacts a lot of other things. This is the highest judicial body that makes final decisions on court cases. And it impacts a lot of things. It impacts direct investment as well. And we now see a lot of stories happening in our relations with the US, especially when it comes to investment, when it comes to other things. And our research says that, the state of the rule of law for the investors is the key obstacle to direct foreign investment. And this is briefly about the importance of the Supreme Court, but also the Supreme Court is the last instance when it comes to the judicial reforms that we are implementing. And during the first panel, it was mentioned on Usate decision on 180 judges that are highly likely low integrity judges. At least we have a lot of information that those are the judges traitors and those judges who were involved in corruption. And some judges are currently working in Russia and in occupied territories as judges. So this is the importance of the Supreme Court. And it was mentioned as well that the 16, 17, 18 reform failed. It was not successful. There were dozens of law integrity judges. Natalka remembers them very well, those judges who passed. And the Public Integrity Council did draw our attention to that, but unfortunately, almost never did they listen to us, and this is the result that we're presented with. And back then, for a lot for our international partners and for everybody else, we had some expectations and we really wanted to believe in the success of the reform. We really want so the result that we achieved back then was considered acceptable. And of course, it was like a cold shower for us when we saw the corruption scandal that involved the former head of the Supreme Court, Knyazov, with the bribe, with a $3 million bribe. And we're not just talking about him, we're talking about other 13 members of the Grand Chamber, including those people who were who had their cash that was identified. And since then, in terms of the Knyazov case and other cases, there is no improvement, there is no reform. And then the Usate case we've mentioned, and there were a couple of other cases, maybe not some large-scale cases that European Commission mentioned as well. So those are the people who also appear in this case. Of course, we have the problem with Russian passports as well. We asked Georgi to facilitate this panel because he has done a lot in terms of investigating Judge Lvov. This is the judge who is no longer present in the Supreme Court and will probably not be present. We will see how the Supreme Court will proceed with that case. But he's not the only one. There is Judge Valentina Simonenko, who was dismissed, and also turned out she had the Russian passport. And when we were trying to find more information about this, the Security Service of Ukraine said there was no Russian passport, but turned out she did have one. Then the journalist identified her Russian passport, and they say it is not; those are not the only judges like that. There are probably more judges who keep working in the Supreme Court, and we're not progressing in identifying them. And as a result, the day before yesterday, we had sociological results. Today it will be presented. 69% of Ukrainians, fully or partially, do not trust the Supreme Court. And the number that we calculated is similar. So among those people, based on whom the Public Integrity Council presented a negative conclusion back in 1617. So there are 51% of law integrity judges in the Supreme Court. So this is among the 153 judges of the Supreme Court. And of course, this percentage would have been much higher if the PIC kept analyzing the judges online, because there are a lot of other things that say that a lot of judges are low integrity judges. This is the situation with the Supreme Court, and the European Commission has said twice, has drawn our attention twice to these corruption risks, and we should talk about this in the Supreme Court through the Declaration of Integrity. And I'm hoping that Victor will probably talk more about the prospects of whether and when the draft law on the reform of Supreme Court will appear. Of course, first of all, speaking about the new judges entering the Supreme Court. And the European Commission explain this in their documents, and we should use the Declaration of Integrity. We should involve international experts, independent experts, and the Declaration of Integrity of these judges should be checked. And it is not And so this is what should be the priority. And after that, after the cleansing, there should be new selection of judges. And as of now, there are about 50 open positions in the Supreme Court, and we should also involve international experts in the selection of judges for the positions that are open right now.
It is very important when we hear calls like select more Supreme Court judges. Obviously, they meant without the involvement of international experts. We urge not to do that. We urge to cleanse the Supreme Court first, because even if we recruit even the best judges for these 40 or so vacancies, I'm not confident. I doubt that this will lead to a formation of a stable majority in the Supreme Court that will be able to make fair decisions. Unless we do this, I will say it again, we will have something sort of half and half, which will create more risks for reforms, because I will say it again, we said every few weeks that the Grand Chamber of the Supreme Court regularly makes new decisions that contribute to a rollback of the previous reforms. Essentially, the Supreme Court is now turning back. Like it says, doesn't matter if you are traitors or if you are corrupt, you can keep working. By the way, I'm very thankful to the High Qualification Commission of Judges and the High Council of Justice that they did not take this bait, so to speak. They don't follow this provocation and continue performing the function and the priority that they have. And I am wrapping up to say that we have 3 myths about the Supreme Court reform. There are more, but I want to point out 3. The first one, which is the most important one, is that if there is a reform of the Supreme Court, there will be an enormous collapse. We have been hearing it for about 10 years, starting from the qualification assessment of judges that was launched in 2010, when they said judges are going to resign and there will be a collapse. About 2,000 judges quit then. It indeed increased the workload of other judges, which we are fighting against now. But this enabled us to organize competitive recruitment that we are talking about today and that we are urging people to apply for. The same thing happened with the HCJ. They promised a collapse if there was a reform of the HCJ, but it didn't happen. Same thing with HQCJ. Indeed, it has a lot of processes, a lot of workload, but there was no collapse. This will not be a collapse. Even if this old guard resigns or does whatever to stop working, it will not cause a collapse in the system. There is also a common myth about unfair repeated verification of judges. This is not a repeated verification. This is a slight amendment in order to verify the declarations because they already exist. This will give us an opportunity to look back on several years. And the third myth about the reform in 2016-2017, that it already happened. But I think the situation with the Supreme Court now is a remarkable illustration that the previous reform was actually ineffective and unsuccessful. So I urge us to prioritize this, because I think that without this reform, everything else that we are doing in the judicial reform and everything that we are doing in this sector, all of this, if it happens to be successful, it will be rolled back by the Supreme Court, by the Grand Chamber of the Supreme Court, and it will die there, essentially. So in order to ensure success of our reforms, we need to make sure that the Supreme Court is reformed. Thank you, Mikhailo. Indeed, as investigative journalists, we carried out a lot of investigations about the Russian citizenship of Supreme Court judges, including Judge Botan Lvov, who was hiding his dual citizenship for over 20 years. And it turned out that he has been a Russian citizen since 1999. And he had a Soviet passport before that, obviously, and so on. About Valentina Simonenko, it also turned out that she was a citizen of Russia. And there is a story in relation to this when the Supreme Court reform was not entirely successful, or maybe it even failed. And due to this, there is indeed a need to have a new full-scale reform that will involve the public council, international experts. But in order to understand whether this is on the government agenda, we need to talk about Victor. You know, recently, the deputy head of the Office of the President, Irina Mudra, published her op-ed in Forbes, where she said there is already a certain strategy of the reform. Does this strategy include these points? What does it include? Can you share this? And does the agenda include a reform of the Supreme Court in the near future? Hello, dear visitors. I want to apologize to Mikhailo for speaking on behalf of Irina Mudra. This is due to significant geopolitical events that are waiting for us in the near future. The Munich conference that is being prepared now. Secondly, I want to point out that there is this counter reasoning to the reform of the Supreme Court. I think it was partially successful. Why? If we compare it to the previous years, not specific periods of this or that president, but the previous years overall, starting from 1991. So if we look at 2005 or 2010, and if we imagine that the head of the Supreme Court can be caught taking a bribe, this would seem something impossible. The fact that this happened, yes, it is a failure that this happened at all, but the fact that there was a criminal proceeding and we understand what is required for such major events. So we understand that this fact was documented is already an accomplishment of the state since 2014. I think it is a big accomplishment and really major. And the partial nature of the success is the fact that this happened at all. If we look at the perfect model where this cannot even happen, then yes, it is a failure. If we speak about effectiveness of the work of law enforcement agencies, National Anti-Corruption Bureau, and the success of involvement of other judicial agencies, that there was no information leaked, that this was all documented through and through. This is a success, I think. If we speak about the strategy of development of justice in 2025-2029, which has already been defined, the part that is dedicated to the Supreme Court has a major role in the strategy. Now the strategy is in its final stages, and I really hope that in the near future, after the strategy is presented, all branches of power that will participate in its approval will have a stage of public consultations. A lot of public comments were already taken into account back in its first draft stage in August. I am confident that you saw the first draft and the second draft. So a lot of those remarks were taken into account. And now all these edits are being made into a single document. If we proceed to the point of those ideas that are included in the strategy, the primary thing is an evolutionary rather than revolutionary approach in the court. We remember that now there are 43 vacancies that need recruitment, and we understand that the number of cases per Supreme Court justice exceeds the average. If we look at this in comparison with other European countries, with Western countries, and we think that this is not very good at this point, and these indicators have to be decreased, for instance, by means of using cassation filters and turning the Supreme Court into a court of justice, a court of law. this is an institution that requires development as well. This is something that will require special attention during the implementation of the strategy and in the process of developing these aspects that we mentioned. If we speak about integrity and the actions that it requires, there is also a big part in the strategy dedicated to that. And we remember the 2024 European Commission report that directly mentions the requirement for further dialogue regarding accession to the European Union to ensure a procedure of reducing corruption risks in the Supreme Court. We will not be able to circumvent this provision, because if we identify entering the European Union as our vector and corruption risks are considered unacceptable by the EU, the government will work to eliminate these risks. How will it be done? Either through additional verification and declarations of integrity or through increased liability. This is an issue of further changes, further legislative amendments, and how it will happen in practice, particularly in the dialogue with our Western partners, who will identify whether we have a sufficient level of compliance with the requirements that we have. In the near future, we'll also have roadmaps, including the roadmap for the rule of law sector. Currently, we know that these roadmaps will be mandated at the international level as part of our mechanism of progress towards the European Union on a cluster-by-cluster basis. And these clusters will include the requirements which the European Commission believes need regulation at this moment. This will include the High Council of Justice, the High Qualification Commission of Judges, the Supreme Court, local courts. There are a lot of moments that will be covered in these roadmaps, and there will be a synchronization between two documents: National Strategy of Development of Justice and Constitutional Justice, and roadmaps approved at the level of the EU that will be recommended to Ukraine for its further progress. So, to sum up, the main steps that will be taken in the strategy to improve the role of the Supreme Court as a court of justice. This is cassation filters. This is procedural opportunities for written proceedings. And the Institute of Law. These are the vectors that are necessary, and of course integrity is the foundation of everything of this. Thank you, Victor. And I would say that you say integrity will be checked. You are saying the strategy will include the point that it is necessary to identify the way to verify integrity and what should we focus on in the process of this verification. We also have with us Josh Kohler. I would like to ask him a question. Josh, could you tell us, with regard to the need to reform the Supreme Court, how important is it, how necessary is it to ensure that this happens together with the Public Council of International Experts? Because we have already seen multiple times good examples of how, let's say, the High Anti-Corruption Court was established. And it was actually established when the Public Council of International Experts was verifying candidates. And we see that in a short period of this court's existence, there have been quite a lot of verdicts regarding grand corruption cases. I think about a couple hundred verdicts. And before the court existed, there were about 30 or 40 cases that were resolved. So looking at this fact, how important it is to ensure the participation of international experts.
Thank you. Thank you. Unfortunately, I will switch to English right now. I apologize, but it's easier for me.
The reform of the Supreme Court is undeniably crucial and, should remain a key priority. I mean, to sort of step back for a moment, I think it is really important to acknowledge the vast amount of reform that is and has taken place in Ukraine. in the judiciary. It's obviously integral for Euro-Atlantic integration, which is unsurprisingly and rightfully one of the key priorities for Ukraine. You know, that also comes with, in the middle of a war, a significant amount of pressure on Ukraine to meet numerous benchmarks. But with that also comes the opportunity, which is there is now probably more momentum than there's ever been to reform the judiciary. And, you know, I've been struck from being here, the sort of dedication and interest on what that means and what that should be. So I think this is a real opportunity for Ukraine, and also because there's a significant interest from international partners such as the UK. I mean, we've been doing a lot through the Good Governance Programme already since 2022, but you know that interest continues to increase, I think, across the board. So when we talk international partners and international experts, I think this is it's crucial, I think, to be able to utilize the international partners that Ukraine has to help with the reform. I mean, when we talk about the Supreme Court, I think it's really crucial to mention a few areas. I think first off, as with all the judiciary, there's the key issue of capacity. You know, there are significant capacity issues across the judiciary, and that creates a real strain on both recruitment and vetting and the selection processes, which is why I think it's really important that this remains a priority. You know, I think the important thing is to find that balance. Obviously, it's entirely correct that we need to be filling, you know, those gaps as soon as possible, but we also need to ensure that the candidates coming in are vetted properly and have integrity, because otherwise, you know, you're just creating further problems down the line. So it's important, while we have this benchmarks and this momentum, to do it in a way that makes it sustainable. And, you know, for us, I think the Supreme Court can provide, or it should be, the perfect example of having it done correctly. You know, as the most important court for Ukraine sitting at the top, it needs to ensure that it itself is working properly. I mean, you know, we've seen difficulties previously in kind of the working relationships, but it's really crucial that the Supreme Court is working in harmony with HQCJ, HCJ, and the PIC. That process needs to be effective to ensure the right appointments are going through as quickly as possible and done correctly. I think as well, you know, I do welcome the progress that's been made, but that is also acknowledging that more progress is still needed. And I think that's kind of the key message from the UK, which is that, you know, we remain committed to the reform of the Supreme Court, and we stand ready to help with that. Our view is that, you know, there are areas that we can help with, whether that be, you know, helping provide international independent experts, and trying to push through the reform where we can politically. I mean, we do a lot through the G7 ambassadors group in Ukraine, as I'm sure you'll all be aware. You know, I think this is a priority for international partners, rightfully. And I think if for Ukraine to really meet and provide sustainable reform in order to achieve Euro-Atlantic integration, the reform of the Supreme Court will be key, because it does sit at the top and therefore will influence the reform taking place in every other court system. So when we look at it from, you know, a top-down approach to the judiciary, the Supreme Court, reform of the Supreme Court is vital, and one of the key ways of doing that is through the correct selection processes. I won't go on too much longer, sorry. You know, I also do want to mention, just while being here at a DEJURE event, that, you know, I also want to acknowledge the important work that CSOs are doing in this space as well. I think civil society plays a really crucial role in Ukraine on this, and it's really important that their expertise is listened to. I mean, we kind of see it throughout when we talk about the various workings that take place. I mean, you know, the important work CSOs have done with regards to disciplinary inspectors, the PIC, and various other things. I think it's really important to acknowledge that as well when we talk reform. You know, I really do want to try and wrap up. I mean, other than saying it, yes, it's a priority. I think the simple answer to your question is yes. We think it is a priority, and we support the inclusion of independent international experts, and are keen to continue supporting that. You know, I really do want to acknowledge that there are significant pressures on Ukraine's system at the moment when we talk reform. You know, this is by no means an easy context to be trying to reform the system, but we shouldn't ignore the fact that there is also significant motivation to do so. from across the board, not just because it's required through the numerous benchmarks, but also because I think there is far more interest in ensuring that reform is done properly, just from the population as well. And I think that also means that these sort of the reform of the Supreme Court can't really wait. The sort of the atmosphere that there is now and that kind of appetite and ambition means that if there's ever a time to do it, it's now. And then it's also about ensuring that reform is done in a sustainable way, where it's not a sort of quick fix that might create issues down the line, but something that genuinely does lead to sustainable long-term change. And again, just to finally wrap up, which I can definitely speak on behalf of the UK, but I think it's true of all international partners that there is a lot of help that we are willing to provide to Ukraine. It's not about us trying to put demands on Ukraine. I appreciate that there are a lot of benchmarks, but I think they come from a genuine appetite to help, because it's considered the Euro-Atlantic integration piece, where often a lot of this falls, is considered a massive priority, not just for Ukraine, but I think a lot of international partners, and it is really crucial for everything Ukraine wants to achieve. So I will stop there, but дуже дякую.
Дякую, Джош.
Thank you, Josh. Now I have a question to Mr. Dmitro. Dmitro Gudima is the judge of the Supreme Court, and he has become the judge of the Supreme Court as a result of the reform in 2016 and 17. And here I would like to talk about the necessity of the new reform of the Supreme Court, but I would like to approach it from the angle that very often the Grand Chamber of the Supreme Court makes the decision that in fact undermine the decision of the High Council of Justice, and sometimes prevent it from from carrying out its duties efficiently. Finally, the council is working again because it's been on pause for a long time, and right now we see positive signals and some negative signals as well, but we do understand that the decisions of High Council of Justice, well, the other way around, if the High Council of Justice makes a decision, the Grand Chamber of the Supreme Court can make a decision that would undermine the work of the High Council of Justice. And what is your opinion on the matter in the context of this situation, and maybe overall speaking on the reform of the Supreme Court, how relevant is it? Thank you. Today, during the event, and specifically during this panel, I noted down some information related to what the participants said, to what the panelists commented on. And I feel like the understanding of reforms, of the notion of reforms, can be quite different among us, depending on who's presenting, who is speaking. And I don't think we can say that if we identify some negative phenomena when it comes to the work of the parliament, the cabinet of ministers, or the ministry specifically, it means that they have to be reformed immediately, meaning that all the people have to be replaced with new people. No. But when we talk about the court, and when we talk about court decisions that what was made and has been enforced, it means that there's a need for reform. So as for me, maybe we should talk about the work of those agencies that should respond to some negative moments in the work of the judicial system. And here I'm talking about the High Council of Justice, and in a way, partly I'm talking about the HQCJ and about the National Agency on Corruption Prevention. I'm talking about the National Anti-Corruption Bureau here as well. So some facts have to be vetted, and some actions have to take place from the side of the National Police of Ukraine or National Security Service of Ukraine. So if we look at some negative actions of the Supreme Court and whether these are the grounds of reforms, the question here, are we so unsatisfied with the work of the bodies that I mentioned that we are sure that the bodies who have the powers to respond to some actions, to lack of action of judges, will not do it, or maybe will do it in the wrong way? So I believe that the institution cannot undergo constant reforms in a way, meaning the very change of the institutions. Of course, fresh blood in the institution is needed, and this is what we've heard during the report of the head of the Supreme Court, and he talked about the necessity of recruiting new judges, and if the country can afford this financially, 1 or 2 years ahead, depending on how the selection will last, yes, 40 or 50 judges have to be selected, but on the other hand, we have to take care of the institutional memory. About 50 vacancies that we have is 1/4 of the composition of the Supreme Court. So we will have a large number of new people without anything that would preserve the institution memory, can lead not to stabilizing the judicial practice, but to the lack of balance in this judicial practice. But I'm not sure that everybody understands this. And especially among those people who raises the question of Supreme Court reform. And in order to preserve the institutional memory in the Supreme Court, we have to have some mechanisms in place, including in order for people to find some conclusions made by the Supreme Court on applying the norms, and so that the people can use this conclusion. And our state has embarked on the way to build a case law system without creating any means for those cases to be documented properly, and so that the judges, included the judges of the Supreme Court and lower courts, and lawyers, teachers, defense lawyers, etc., to work with this instrument. And the Unified Registry of Judicial Decisions was not created for that purpose. Of course, we have all the decisions there, but it's hard to navigate anything. And even when we hear what the high qualified lawyers say, they say that there are a lot of attempts made by the Supreme Court to make contrary decisions. And in these cases, this criticism is baseless, at least because the judges and people who raise these issues have different visions on the conclusions of the Supreme Court and on the circumstances these conclusions were they made that. So maybe there's a lack of mechanisms to document and search for a decision or for a conclusion made by the court. Of course, we will not establish a system where there will be no contradictory decisions at all, but the idea is to have the mechanisms of bringing together these decisions. And unfortunately, the way I see it, there could be some usefulness in cooperation with international partners to establish a project where the judges of the Supreme Court and some employers of the Secretariat of the Supreme Court will learn about the system of documentation and accounting of cases in the countries of common law. Maybe, for example, in the UK, a motherland of case law, because it cannot be the case that what we learn from the experience of other countries, but we have no foundation to establish the system. We need the foundation, and each year when it comes to looking for case law, the system will deteriorate. And currently in a lot of cases, a lot of positive results are based on the memory of those who made decisions during the past 6.5 years. But this should not be the case, because when we are considering the case and somebody remembers that we considered the case 5 years ago that is similar, let's look for the case. And can you just imagine what will happen when we hire 50 new judges without this institutional memory, but we have no means to look for the case law, the decisions that have been made? And this can lead to even more differences in the judicial system. And here we need the support of the state that should notice the problem and support its solution. And there are a lot of other issues at the global state level. For example, the career of judges, the career of the employees of the secretaries, offices, not only of the Supreme Court, but other courts, the competitions that have been announced by the High Qualification Commission, they demonstrate a sort of lack of desire of the representatives of private business to switch to the state position and serve as a judge in the state system. And if we look at the number of vacancies and the number of people who would like to to choose this career, we cannot say that highly proficient and qualified lawyers would like to become a judge. This is not the case. And if we look at the competition, we can say that the situation will be similar or even worse if we announce the competition to the Supreme Court. For those who remember the previous two stages of the competitions for the Supreme Court in 2016, 17, and 19, you can see how the number of applications changed. So this is something that we should think about. We should think about the mechanisms to encourage people to participate in these competitions. And this encouragement cannot only be limited to the calls, please apply. This is not effective. We have the consultant of the Supreme Court, the secretary of the court. They have similar salaries, but have very different duties. They have no prospects in this system. And the secretaries of courts have no prospects either when we talk about lower instance courts. Same when it comes to judges' assistants. And a lot of people work as an assistants to a judge. They work there to a quite advanced age. And, well, instead of becoming a judge, the person who is assistant to a judge is ready to quit the system and say, I am ready to switch to the private business now that I have the vision of the judicial practice, of how the court works. When I'm 40, I will better join the private sector instead of applying for a competition to become a judge. And this is the problem. And a lot of us do not notice the problem, whether on purpose or not. This is another question. There are other things where the state participation, even without additional budget funding, is important. It was mentioned today that there is a need to improve cassation filters, and this is going to be provided for by a certain program. And there is a necessity to improve this. But the problem with cassation filters, there's one problem. They proved to have very low efficiency. Where I work, on average, we have 5 complaints per day when everybody is here. We don't have many judges. We have 30 judges, and if some of them are sick, if some of them took a day off, the workload per person is greater. Instead of 5 cases, we have 7 cases per person. If a couple of colleagues took a vacation, it can be the case that one person gets 20 cassation complaints. And how can you consider those during 20 days as it is provided by the law? And in addition to, well, a person needs to read that, to process that, and to produce result. And in many countries, there are mechanisms where the judge does not participate in the preparation of a decision of the case for consideration. So it's not the judge, but the employee of the apparatus to look at that. And they are responsible for calculating the court fee. It might look simple, but it's not that simple. It's the responsibility of that employee to look at the documents, etc.
And these technical issues, if there are 2 panels that went on holiday the same week, one person can have 100 cassation complaints in a working day, and you need to write about 40 refusals to start a case, which is the average percentage. This is not the same kind of refusal that is written, and as the 60%, you need to explain the shortcomings if there are any. And sometimes in certain countries there is the position of a reporting judge who is selected for a certain period of time, for instance, a year in the judicial structure, who only performs the filtering of cases at the initial stage. let's say the cassation complaint comes in and their job is to use these filters in order to work on the incoming cases. They present the decision whether to start a case or not, whether there are shortcomings that need to be fixed. Maybe this is also a possibility that we could use, or we could delegate something to the apparatus of the court. This all takes more time than actually judging a certain case on its merits. Should a judge sit with a calculator and make sure that the judicial fee was paid correctly? Or is it correct that the verdict of the Supreme Court has to include the calculations of all the court fees? As a Supreme Court justice, you have to actually recalculate what happened at every instance before you. What does the judge have to do with all these budget items? If we speak about a reform, we need to improve the procedures, to improve the administration of justice itself. A judge shouldn't have to perform functions that are foreign to the judicial activity per se. And in my personal experience, maybe it's not a lot of experience, 7 years with the Supreme Court, I think that fair trial of cases means fair procedures. And if we speak about international standards, we need to have real justice, and we shouldn't consider the court as a fundamental of life or justice in the entire country. If we imagine this temple, as it was mentioned at the beginning, we have this foundation, we have columns and the attic. The foundation of everything is the first instance court. They are the foundation. They are the ones that are closest to people, that communicate with them. The Supreme Court doesn't and cannot communicate with everyone. Then we have the columns, and the Supreme Court is the attic, so to speak, that should ensure the unification and stability of case law. But it cannot help every person with their individual problems, because if that happens, people have a skewed understanding of what this institution even does in the first place. Because even if the amount or the decision of first instance and second instance courts is unfair, the person will go to the Supreme Court and try to go there. I'm thankful for your emotional presentation, I would say, and I would like to invite Mr. Zhirnakov to speak, because I feel that he has something to say about what Victor said, what Metro said. Thank you, Hillary. Thank you for tracking our time. While Masi is not here, he also apologized. Apart from the fact that he's also he's a lawyer, he's also a military servant, and he had some urgent things. He said he's on his way, but it will take him a little time. So I will try to take the floor while he isn't here and respond to what Dmitro said, and maybe clarify on something that Victor mentioned. I think that things are actually quite simple. The institution is functioning, the reform is successful, then we support it in its activity. If it doesn't work, we continue reforming in this. We already mentioned a story today when the NACP was rebuilt, was actually built from scratch. The Supreme Court existed. And the idea was to completely rebuild the Supreme Court as well, because things didn't work, or they worked only partially. I think this effectiveness is dropping with a decreased number of honest Supreme Court judges. The NACP failed the first time. We reformed it completely, even though it was a new agency, an anti-corruption agency. Why did we do that? Because it didn't work. Not everything will work from the first try. It is not a single decision that we are urging to complete the reform of the Supreme Court or to make it effective. We speak about bribes of millions of dollars, houses of costing millions of dollars, Russian passports, and aggressive opposition to reforms. And we have spoken about all of this. The argument that worked until recently, which was tell us what the Supreme Court did wrong. I think we have a QR code somewhere here. We actually collected all the information about the Supreme Court, all the facts, how it opposed the reforms. This is a priority in our European integration. Will we join the a European Union with the kind of reforms that we have now? I'm not talking about Katerina Maternova, I'm not talking about our colleagues from the European Commission, but I have worked with in this area, and I'm saying no, unless we complete this reform, we cannot join the European Union and will not be able to do that. As for the popularity of competitive recruitment, 238 candidates. As for how many actually showed up, that's a different thing. But we had 238 judges per 25 spots. And back then we had about between 9 and 10 judges per seat. Before the war, even despite the crisis of personnel that we have now, where we have a proper procedure, where we have the PCIe, the coefficient didn't even drop. I don't remember the specific numbers between 2017 and 2018 when people saw it happen in 2017, those who believed in this competition. Of course, in 2018, fewer people applied, considering how the competition took place. With all due respect to all those judges who were able to join 2018. It would be good to have stability in certain issues. The decision about Usatый that was included, unfortunately, in the report of the European Commission, he had quite stable case law. And his position is that a judge should be in the plenary if he is supported by the PCIe. Then there were 3 more low integrity judges who joined the Grand Chamber, and the case law changed. Of course, this is not the best kind of stability. What is it about? I think it can be connected with the fact that I think we have about 20% of judges who are progressive, who were joining the Supreme Court from the non-judicial background. This used to be an effective procedure. Now it no longer is. Like something happened and now things stabilized. Now there is the head, like the president of the Supreme Court, not the one that was caught taking bribes, a different one. So it is clear to us that instead of moving with the times and supporting the judicial reform, the Supreme Court actually opposes these reforms. And the last point is about evolution versus revolution. Oh, and I forgot to mention these 25% that you are mentioning. I don't know if they will be able to maintain or to break this bad institutional memory that exists now. This is very little. Even if we recruit super progressive judges for these 25 positions, this may not be enough. So in order to make this reform successful, we need to remove low integrity judges, obviously low integrity judges, and only then can we recruit new personnel, like in the story about the jar and the pickles. If you add fresh pickles to a rotten jar, it will not save the entire jar, unfortunately. And in terms of evolution versus revolution, we have the evolution now. We have the tool of declarations of integrity, but there are no time frames. And I understand that there is an enormous workload, but considering the priorities of this verification, I don't know how the HQCJ feels about this. I think that only 2 people were verified under this tool recently. And even despite the PSC's conclusions, this did not result in anything. So we need an improved tool that is reinforced to cleanse the Supreme Court as it should be, and then recruit new ones. Thank you. Thank you, Mikhailo. We have about 5 minutes before the Q&A session. So I suggest that Victor can comment on what has already been mentioned. And then I will ask Dmitro. I actually have a very short comment about the revolutionary path. If we look at the statistics of vacancies in the courts of appeal, currently this figure is 66%. That is currently out of 100% of all the appeal stage, only 34% of judges are currently doing their jobs. We all know that in some regions we have courts of appeal in some areas where they cannot even have a 3-person judicial panel. So speaking about revolution and evolution, we at least need to maintain those 34% of judges who should administer justice in the meantime, so that we don't end up in a situation when we have 0 judges in a certain instance. This is a danger, and even if we speak about functioning of the Supreme Court, I completely agree that we cannot speak about criticism when we have only 75% of judges, but we can speak about evolution in cases when we have only 34% employment rate in the second instance. So about where we can take the revolutionary path and where we can't, this is about the logical decisions in this case. And in that case, the reform will be effective and improve the situation. Dmitro, I will ask you to briefly comment on the statement. About what Mikhailo said, perhaps the public can and should provide a simplified and quite critical assessment of the situation. But I think it would be fair. It wouldn't be entirely fair to say that the Supreme Court is a foundation of opposition to reform. A functional institution cannot fully oppose any reforms. It may have its vision how things can be improved. This vision can indeed be very different from the vision of the public, but this does not mean resistance to reform per se. The Supreme Court, like other institutions, is an institution of our country. We live here, we defend this country. So turning one agency into an enemy in the public eye is a big mistake, particularly when we take into account certain corruption scandals that were in this agency and in other agencies. A reform never means that we replace every single person, and I feel that an adequate vision of the situation should be about improvement of those procedures that exist today, which Mr. Dubovik spoke about, Mr. Zhenkov spoke about as well. We can get better quality by improving things that we have rather than creating something entirely new and spending money on this from scratch. Thank you. Thank you as well. Now we have an opportunity to ask questions. I see that Anton has a question. Anton Zelinsky. Let's give him the mic. Yeah, I have a question to Dmitro. You are saying that the reform is not a global reform, is not it's not the right time for it. But what do we do about the fact that 4 heads of high specialized courts that were liquidated and were made part of the Supreme Court, remained in office. They became heads of cassation courts within the Supreme Court. So the question is whether the reform happened at all. You also said about cleansing and bringing to justice Knyazev's case, for instance. He was partially brought to disciplinary liability already. There is a criminal case against him. But as we know from the judicial hearing, where some recordings were published, Knyazev asked to divide the money into several packages, and there were judges who were found in possession of this. For instance, Judge Anna Yelenina, but there was probably not enough evidence to send these materials to court. And the fact is that there were marked banknotes that were found with a Supreme Court justice. He wouldn't be asking to divide the money into several bags if it was only for him. But nobody was brought to justice apart from him. It has been over a year and a half, and this hasn't moved anywhere. The Grand Chamber indeed adhered to certain case law for 8 years. Now we have new members, and we see this case law being dismantled. And we see that their decisions do oppose the judicial reform, because for 8 years the Supreme Court supported that the Public Integrity Council has to participate in these processes, and now the Grand Chamber said that this is not necessary. Then we also have to mention the decision of the Grand Chamber that interferes with the decisions of the HQCJ and HCJ. So what do you think about this? You know, you have a few questions in your intervention, and I feel that a lot of this are good points. Do agencies that have to bring judges to liability, are they working effectively? Probably not. But what does this have to do with the reform of the Supreme Court? It's not the court that has to bring its own judges to liability. Those who are guilty of a crime should indeed be punished, but we shouldn't destroy an institution instead of improving the procedures of its activity. You are saying that there is a degradation of case law. I am actually very much against this terminology, because I feel this is disrespectful towards the court and its decisions. But change of the case law is a result of replacement of many members of the Grand Chamber. Why was this possible? Why did the balance of votes change? Perhaps this is due to the fact that legislation does not regulate this. It does not clarify the behavior of a judge who joins an institution that already has an established case law. And the legislation indeed does not say that if a person is elected to the Grand Chamber and this person joins it with their own vision of how it should work, of all these things and how they function. This isn't there, even though it is in the spirit of justice to follow the priorly established practice in a country that survived dozens of years of positivism. We cannot hope that there can be unwritten principles of justice. We can hope, but as you see, it is not always effective, and there can be a change of case law where you don't expect this, but where legislative procedures say nothing about this, say nothing directly.
You do understand that if the law prohibited directly that the judge votes for the contrary decision without the substantiation, the judge wouldn't do it. The judge wouldn't vote without any substantiation, because they would have an understanding that this is prohibited. This is not something that should be done. I do have this understanding, but that's not because the procedures are perfect, but if we see these phenomena, it means that we have to correct the procedures. If, because of some drawbacks of the criminal and procedural code, cannot be held brought to justice, this is not the ground for dismantling the court that ensures the unity of judicial practices under the conditions that we have, not considering some humiliating facts. The court works quite well. I talked about the problems that we're facing every day. And these problems roll the Supreme Court back, not because of crimes, offenses, but because the court cannot adequately perform its duties under the law, meaning ensuring the sustainability and unity of the judicial practice. Because of the context, it's not always possible. And we say, let's reform the institution because we have some humiliating facts, and the governmental bodies cannot conduct the investigation and bring the people responsible, bring people accountable. And this is, should we do it just related to one court of the country? Well, if we follow this example, let's look at other agencies. For example, in one agency, let's not name it, some person was caught taking a bribe. Let's reform the whole agency? Well, maybe if we look at the popular perception, maybe the idea is not bad, but will the quality of work improve? This is a big question. You cannot be sure of that. Even if you appoint or select the people to the body that are in line with all the criteria, the work of the institution depends not only on the personal criteria. The integrity and qualification of the person is one of the criteria of the institutional work, and the procedures that are provided for by the legislation is another thing. And without those procedures, the institution will not work adequately. Because I heard from your speech the necessity to improve the procedures, not only related to the Supreme Court, but those related to the National Anti-Corruption Bureau, High Council of Justice when it comes to disciplinary liability. Yes, we can talk about those problems as well. During 6 years in the Grand Chamber, I considered the disciplinary questions as well, so I can comment a lot on that. Thank you. And thank you, Dmitro. We had another question. Could you please pass the mic? Hello, Inna Vedernikova, Дзеркало Тижня media outlet. It's very good that there is a discussion and there is not just one voice presented here, and this is actually the way towards finding a balance. On the one hand, we do have bribes, we do have the necessity to cleanse the Supreme Court, and on the other hand, there is a risk to dismantle the institution. And as George mentioned, it's very important to think about the sustainability of the reforms, including the reforms of the Supreme Court. So I'm really urging you, all of the speakers, so that the journalists have an understanding which are the ways that you see moving forward in this process. Each of you, could you name 3 points how to achieve the balance, in your opinion, so that we both cleanse the Supreme Court and boost its effectiveness, and at the same time we do not disbalance or dismantle the institution and preserve sustainability? So could you name 3 points? Okay, Victor, let's start with you. That's a very interesting question, and if I should name only 3, well, in my opinion, there should be a separate point: integrity. And this should be a separate point because this is critical for the work of all government agencies. And another separate point is those procedural opportunities and legal norms that guide the work of the Supreme Court. Like I said, but in the document that is about to be signed by the President of Ukraine, it mentions the cassation filters and other institutes. So we have 4 procedural points there, but the key point here is the integrity. Thank you. And Mikhailo, thank you. I would like to clarify first of all, because we kind of diverted in a different way in our discussion. Well, because we started talking to whether about should we just dismiss everyone, should everyone be resigned? No, that's the first thing. Another thing, maybe I didn't get things right, but on the one hand, when you make a decision, I mean the Supreme Court, and well, there are problematic decisions. But let's not reform us. We will deal it on our own, with it on our own. But when we talk about the judges of the Supreme Court and delegation to the Grand Chamber of the Supreme Court, you're saying, could you please write this in the law who we can vote for? I think this is contrary to the principle of self-governance, because if the institutions cannot understand that law integrity judges with proven facts of lies in the declaration and other aspects should not be delegated to the Grand Chamber, then maybe, well, I don't think the law is the solution. Which legislative solution would you suggest? We should talk about effective cleansing and vetting of everyone? Yes, but then we should apply individual principles, and for those people who are not in line, they should be dismissed. So this is the effective cleansing. We should also have effective selection, meaning the just selection. And the third part are international experts, because without international experts, at least for now, we can see that it's very difficult to deal with it. So this is something that works. So right now it's clear. We see that the downward trend. So I think those are the 3 points. Thank you. Joshua.
I would probably start by echoing the point on integrity. I think integrity is crucial if we're talking about sustainability and genuine reform. The second one, absolutely, I think it comes down to the selection processes, ensuring that we've got good integrity checks, ensuring that we've got the sort of international independent experts to take part in that, and ensuring that therefore the people chosen and the candidates chosen and the judges already taking part are properly vetted. And then finally, I would say it's sort of the wider working relationships. I mean, I mentioned this when I initially started, but how the Supreme Court works with the various functional elements of the judiciary to ensure that we don't have kind of tricky judgments that can slow down the sort of efficiency and workings of the wider judicial system. So I think that working relationship between, as I said earlier, the Supreme Court, HCJ, HQCJ, PIC, PCIE, it will be crucial if we're talking about genuine sustainable reform. Дякую.
Дякую, пане Дмитре.
Thank you, and Metro. Thanks a lot. Having listened to the presentations, I think that I agree with Mikhailo and what he says, because I do support the legislative integration into the work of the government bodies, where the bodies cannot deal with their duties and need the integration. And those, maybe I will not present them in the systemic way, but on the one hand, I think it is necessary to decrease the demands to the text of cassation complaints, because those people, especially those without legal background, they cannot write the cassation complaint effectively. And, the public doesn't take it well. And on the other hand, we should strengthen the cassation filters and give more opportunities for discretion by judges of the Supreme Court when they open cassation cases, so that the court can fulfill its mission to ensure unity and sustainability of the judicial practice. So this is for the cases when the text of the cassation complaint is not perfect, but it's clear that the judicial when the actions are not in line with the practice. And unfortunately, we have to decline a lot of cassation complaints, not without regret. And the other one is the implementation of a sort of an institution of a judge rapporteur who will prepare the case for consideration. and we'll look at the cassation complaints, we'll read them, we'll correct some shortcomings, we'll calculate the court fees, we'll see what has to be amended, and then we'll send letters or other documents to the parties of the case so that they correct all the shortcomings. And the other opportunity, as it is the case in other countries, these functions can be transferred to the secretariat of the court. For example, the consultant to the court, there is a position like that, could take on these duties, and it doesn't mean that the judge cannot intervene when they discovered some drawbacks in the work of their consultant, but this routine should not be delegated to the judge because it takes more time than the consideration of the case, but almost nobody knows about it. Thank you, and thank you, Dmitro. We have 1 or 2 minutes. If there are more questions, you can ask them now, and if there are no questions, so let's say thank you to our speakers. Thank you for this active discussion, for this vibrant discussion. It was very cool, and I think everybody had a chance to share their thoughts, share their worries, and thank you, Hori. Just like an advertisement, I'm hoping that you can see the QR code on the screen. So following this QR code, you can look at the materials that cover all the problematic issues that we're observing. And because of these problematic issues, we are suggesting what we're suggesting right now. So please scan the QR code and take a look at the materials. In just a couple of days, these materials will be translated into English, and you can follow the same link to find it. And in your folders, you also have some materials related to it. You have more information about the reform of the Supreme Court in your folders as well. Thank you. Thank you, and let's take a break. Thank you, dear colleagues. Let me
Шановні колеги,
Dear colleagues, thank you for coming back here on time. We continue with our work and we're going to have a very interesting session, not only for those people who have delved very deep in the judicial system, but it's going to be very interesting for everyone and our partners. So we're going to talk about the participation of international partners in the competitions, and a journalist, Oleg Novikov, is going to facilitate this session. So, Oleg, over to you. Thank you. Good evening to everyone. And this is going to be a final panel discussion. We're going to talk about international commissions that took part in the selection to judicial bodies. And our participants are Vice Prime Minister for European Euro-Atlantic Integration, Minister of Justice of Ukraine, Olga Stefanishina. She will join us online. We're gonna have the head of department on European integration, rule of law, and civil society, Asir Satyan Luzuriaga. Manager on international relations of the Euro Foundation, Nestor Barchuk. Also, Tatiana Shevchuk, head of international relations of Center of Countering Corruption, and we have Andrei Kozlov, member of the Competition Commission on the selection of the head of the NACP, and we have the representative of the National Charitable Fund of Sergei Pratula. So Olga Stefanishina is running a bit late, so maybe let's start with Nestor, who is going to present the report on the participation of international experts. Thank you. Thank you for giving me the floor. Just a moment. First of all, why was there a need to invite an international expert? That was because after the Revolution of Dignity, Ukraine introduced one of the standards of the European Council, of the Council of Europe. And based on these standards, the judges had to be selected by judges. So based on that, the judicial power received more independence as compared to what it had before. But this standard should have been given only after the judicial power was reformed, because before that it was filled with low integrity and corrupt judges. But after it received more independence, it only promoted the fact that the status quo was preserved as it was, and the judicial self-government bodies that were supposed to counter corruption and introduce punishment for low integrity judges have become those roots of the corruption and low integrity in the judicial power that was formed in Ukraine. And the participation of international experts has become the silver bullet, this foundation, or should have become this foundation for cleansing the judicial power so that it gets rid of the low integrity judges. And I think the best success story that has happened to the reform, to the judicial reform of Ukraine during the independent Ukraine, is the establishment of the High Anti-Corruption Court that was established with the support and with the involvement of the Public Council of International Experts. This is the body that included 6 international experts, and they had very good reputation. They were highly professional, and they conducted an exemplary selection. And as a result of this selection, the low integrity judges were not appointed to the court, and the Public Council of International Experts had the veto right when it comes to low integrity candidates. And as it has been mentioned today by our colleagues, during almost 5 years of the work, the court has issued over 200 verdicts, which underlines the effectiveness of this body. Because the selection to the High Anti-Corruption Court and the work of international experts and in particular the Public Council of International Experts, their work was so high quality and was not subject to any external impact. It was substituted by a so-called mixed model, a model of mixed selection commissions, and the Ukrainian judges or Ukrainian political appointees were also part of this body. And despite the fact that in these mixed selection commissions, international experts did not have the right of the majority vote, this body demonstrated lower efficiency as compared to the Public Council of International Experts, and there were a couple of reasons to that. The first reason was that in these mixed commissions, the Ukrainian appointees, the Ukrainian judges were then appointed by this Council of Judges of Ukraine, which took an active part in delaying the reforms when the reforms started. And the head of this council is Bogdan Monich, who is, well, we know him from the Vovk and Portnov story, and we also know the Council of Judges because it continuously delegates or nominates the worst candidates for the selection commission of judges. For example, this is Volodymyr Severin, and his kids in a couple of years received dozens of apartments in Kharkiv, and the Council of Judges also nominated Yuri Tresun, who is famous for not improper declaration, and the Council of Judges nominated Yaroslav Romaniuk, who was the head of the Supreme Court during Yanukovych times and who supported the dictator laws of 11th of January. And his deputy was Volodymyr Kuzmenko, the Maidan judge. And Pavlovov called him our judge in the tapes. So it's clear who the Council of Judges supports in this reform. And finally, when they are highly professional and international experts with good reputation and professionalism as one part of the commission, and the other part of the commission are the Ukrainian judges with the histories that I just mentioned. As an example, the decisions of these commissions are unfortunately always somewhere in between because they are a compromise among international experts with high integrity standards and Ukrainian judges whose integrity standards are unfortunately, well, for now are very low.
So, of course, we believe that the format of the Public Council of International Experts, who showed much better result in the judicial selection for the High Anti-Corruption Court, is something that is much more desirable in the judicial reform in Ukraine. We recently carried out research. It's very recent. It's like 1 or 2 days old. We asked people who should have the decisive vote while selecting judges for judicial governance and judicial agencies. Over 56% said it should be international experts. Less than a third said it should be representatives of the Ukrainian government and judiciary. We carried out a similar survey in 2023. The numbers were quite similar at that point. We had about 53 versus 47%. So people are supporting the decisive vote of international experts even more now. However, there is a risk now regarding the tenure of international experts who showed good results, because this tenure is expiring soon. Because reforms of the international commissions for the Constitutional Court, for instance, actually, the reform meant that these international experts became part of the selection commissions. And eventually, after the tenure of international experts ends, according to the legislation, they should be replaced with Ukrainian representatives. As for the problematic tenures that end soon, is the mandate of international experts for the selection commission for the High Qualification Commission of Judges, which expires on the 1st of June this year. The Public Council of International Experts, their tenure ends in November 2025. Same thing with Ethics Council and Advisory Group of Experts for the Constitutional Court, which expires in 2029. And actually, after international experts' mandate ends, after their tenure is over, they should be replaced with individuals who will be nominated by unreformed so far agencies, such as the bar. By the way, speaking of the bar, the leader of the Ukrainian Bar Association is Lydia Izavidova, whose tenure was supposed to end in 2022, but she intentionally does not convene the council of attorneys that can select a new leader of their association, and thanks to this, she remains in office. She is she has close ties to Medvedchuk, and as long as she is the head of the National Bar Association of Ukraine, the association never condemned and rather supported low integrity lawyers. It supported attorneys to become collaborators. She helped persecute lawyers who joined the armed forces. So I don't want to generalize right now, but giving the National Bar Association of Ukraine an opportunity to nominate people for commissions that will select judges or members of judicial governance agencies appears a bit surreal. So what needs to be done in order to prevent this? First, of course, we need to extend the participation of international experts in existing selection commissions, but this should not be linked to a specific date as we see now. It should be tied to specific events, such as Ukraine completing chapter 23-24 of the EU acquis, which will show that the rule of law in Ukraine has finally been formed or sufficiently developed so that the participation of international experts is no longer necessary. What is important here is to say that if we link the participation of international experts to years or some other numbers, months when they participate in the reform, we sort of encourage the judiciary to delay the implementation of reforms until international experts are no longer members of these commissions. Among the recent examples, the HQCJ while selecting members of the HQCJ, the selection commission proposed two good candidates, and eventually the HCJ did not select any of them, and nobody was appointed. And I will remind you that international experts will be in the commission until June this year. And if we continue the participation of international experts being linked to specific dates, we will have to extend their tenure in each specific commission several times. And during each such extension of their participation, of course, we will see how the opponents of the judicial reform are trying to reduce their influence in these commissions. For instance, they may demand that the international experts don't have the decisive vote in the next iterations, or they can otherwise reduce their influence. I gradually moved on to the opposition to engagement of international experts. The argument that we often hear is that the participation of international experts in selection commissions is a threat to Ukraine's sovereignty. This sounds like quite a broad issue, and we hear this from many colleagues, many partners. We should keep in mind that any commissions involving international experts never make the final decision. The final decision is always made by a sovereign Ukrainian government agency. Such commissions only carry out selection of candidates for judicial governance agencies or courts, and then Ukrainian agencies appoint or approve the selected candidates. The second point is that selection commissions with international experts undoubtedly show better results than exclusively Ukrainian commissions. For instance, the High Qualification Commission of Judges, which carried out selection for the Supreme Court in 2016-2017, versus the Public Council of International Experts that selected judges for the High Anti-Corruption Court around the same time. We see the issues that we have with the Supreme Court that we already discussed today, and we see that, in contrast, the High Anti-Corruption Court is not surrounded by this amount of scandal and this number of problems. In addition, of course, the participation of international experts should not be permanent, it should only be temporary, and here is what we propose. In opposition to the issue of sovereignty, is that international partners can nominate Ukrainian experts who have great expertise with verification of Ukrainian judges' integrity, and thus the majority of such commissions will consist of Ukrainians. This may counterbalance the high payment that is required by visiting experts, so it is actually beneficial for the donor states. And the second point is that the reform has already made enough progress. So after Ukraine received the status of the EU candidate, Ukraine thus has done enough for this selection, and we don't need the participation of international experts anymore. We can do it by ourselves. Again, if we give up the participation of international experts in the judicial appointments now, we will have low integrity nominees, first, and second, we are currently at the stage when the judicial reform has just started showing good results, and stopping the participation of international experts would mean a rollback to the point where we started. Finally, the Venice Commission recommended the engagement of international experts in the participation of judges and judicial governance representatives, and it recommended that it should be done until results are accomplished, that is, until the judicial system is cleansed. Unfortunately, at this point, we cannot say that our judicial system is fully cleansed and thus can be considered fully qualified to work itself. Thank you for your attention. Of course, the judiciary and the development of rule of law are a part of the most important reforms for Ukraine's European integration, and unfortunately, it is impossible without the international experts at this point. The experience of our previous selections shows that the participation of international experts is highly successful and crucial. And if we give up work with international experts, this does not mean that we will maintain or restore sovereignty in some way. On the contrary, it will mean that that Ukraine may go back to old corruption schemes and the system that existed before the beginning of the reform. Thank you. Thank you, Nestor. We have with us our guest from the EU representative office in Ukraine. So I would like to ask Mr. Asier about his opinion. Should we link this tenure to specific dates, or should this be until specific results are accomplished? Good evening to you.
Good evening, everybody. The use of international experts in the selection for judicial bodies has been a subject of discussion in Ukraine in the past, and it is again. I mean, your question comes from a discussion that it is ongoing in Ukraine at this particular moment. But the European Union and its key international partners, such as the G7, considers important to preserve the international participation in key selection processes, since they have contributed to achievements towards consolidating rule of law reforms in Ukraine. And the study just presented by DEJURE shows that the Ukrainian society is also supporting them. A dozen of such mechanisms are in operation to select the heads of anti-corruption institutions, members of judicial governance bodies, and the Constitutional Court of Ukraine, for example, or the High Anti-Corruption Court of Justice. Well, the judges of the High Anti-Corruption Court. Although sometimes a little heavy in coordination, they are a well-established practice and have provided the necessary reassurance in terms of transparency and integrity, which contribute to re-establish public trust in the rule of law, including in our 27 member states. Certainly, several models have been put in place, most of the time in ad hoc manner. And maybe it is the moment to rethink the approach and start looking at a potential standardization of these processes. Because the devil is in the details. And I will try to answer your question, but for example, in our opinion, all the successful ones have been ensuring a meaningful role for international quota, a casting vote. However, as well presented before, lately, there have been proposals to limit the meaningful role of internationals. And this is not supported by the European Union. The ratio of international members is also under discussion. In some cases, there are commissions with only international experts. Sometimes the ratio is 50% internationals and 50% nationals. And in fact, we think that this is, for example, a good ratio, since it is advisable to share the responsibility, strengthening the ownership of the process. On the duration of the mechanisms, the Venice Commission has reiterated in several occasions that the international participation in selection of judges should be transitional. And we support this, as referred before by our ambassador in the opening remarks. Definitely, we should start debating about this also. But the time And then in this regard, I will put the question of that you also mentioned is what is more important, timeliness or the effectiveness and the quality of the process? For us, definitely is the quality of the process. Something that is also put in question is whether they need to be focused on integrity checks only or also look at candidates' professional competencies. There are other questions as well as the number of selected candidates nominated for subsequent appointments by the authorities, or how much should we reproduce these mechanisms in the SBU, in customs, in police, or should they be extended beyond leadership, judicial selection, for example, to civil service, to reconstruction? How to address the limited number of quality candidates is also a question. And can we compromise on the timeliness of the process versus the quality of the result, as mentioned before? Too many questions, in fact. Nonetheless, acknowledging all those questions, there are key lessons learned that I would like to emphasize as well. Mechanisms need to be addressed within a clear legal framework. A legal framework that determines their temporary nature, ensure a casting vote, define the concepts of assessment and related criteria, ensure their autonomy, provide no temporal nor territorial limitation to background checks, and should be based on the reasonable doubt standard of proof. Operational and financial concerns are key also. A selection commission needs an empowered secretariat that can address legal and the context issues and support the internationals. But also, they need to have effective access to accurate and on-time information, and it hasn't been always the case. The commissions, they should operate within realistic deadlines as well, and often imply to share donor support that requires active coordination. We have requested our flagship project on anti-corruption, the UACI, to make a study on this matter, to dig deeper and bring comparative experience accumulated in other enlargement countries to help answer the above questions. Because this is important, we need now in 2025 to think how to move forward, how to keep working on this, but also based on the experiences accumulated not only in Ukraine. Finally, I have mentioned it before, but let me reiterate it again. For the EU, the model comprised by 3 national experts and 3 internationals with a casting vote for international experts appears to be successful and appropriate in the current context. And it should be preserved in the near future and supported. Rule of law reforms will take several more years, and it is important to preserve active participation of international experts in the selection panels in this transitional period. Thank you.
Дякую, пане Лосєр. А є у нас
Thank you. Is Olha Stefanishina with us already? Good evening, Olha. Olha, we have a question to you regarding your 2 statements. The first one was made in December and was related to the participation of international experts in the competitions in Ukraine, and you said that you would refuse the participation of international experts in the future. And there is a fresh statement on Ukrinform where you said that you would not refuse their participation. So what is your position related to international experts, and especially when it comes to the term of their tenure? Especially when, as Nestor said, in some commissions, the term of their powers is running to an end, so we should either continue their powers or do something about it. Thank you. You actually outlined a similar position. It's just related to different issues. Of course, nobody is planning right now to seize the work of the commissions that include international experts, where international experts has the majority of vote. So this format was introduced to strengthen the trust to the institutions that are being formed. And as you know, today the law on ARMA was voted in the first reading, and yesterday the committee approved the draft law on creating a specialized administrative court that also involves the same procedure. At the same time, my position, my vision related to the roadmap is the following. The trust to the state is shaped through powerful institutions. So right now we have to start thinking about how to transition to the format where the Ukrainian agencies, be it judicial bodies or other agencies, are capable to ensure the assessment of integrity that are capable to ensure this integrity. And when these agencies will have the same mandates, so this is something we should start thinking about right now. And right now we see a couple of problematic issues. First of all, you probably know that the contracts with the members of several commissions supported by the US have been stopped, and I have confirmed information that some commissions have stopped their work. And right now there are negotiations ongoing on funding. So those are related to several commissions related to the judicial bodies, and we're also talking about the expert sustainability and unifying the approaches. So there should be criteria and there should be efficiency. And of course, the positive effect that results from the changes, such as the legislation on Constitutional Court, on High Anti-Corruption Court, on bodies of judicial self-government. So this is something that contributes, this is about the trust to the process, the trust to the selection, and the trust to the persons that have been selected. And we have the negative consequences as well, such as delaying of the process and the lack of specific responsibility. This is what's needed to make the process effective. And we do not see the motivation from the commissions to move faster, to for example, the competition for Constitutional Court is lasting for over a year now, and when it comes to the advisory body that ensures the selection and assessment of the integrity, did not expedite its work, even despite the fact that the powers of the justices of the Constitutional Court have run to an end. And there is some decisions are still not made, so there should be balance there. And this is part of the European integration, and the decision that Ukraine will be a member of the European Union is made when there is trust in institutions. And when we talk about first chapter, when we talk about cluster 1, the fundamental rights, we understand that this is the chapter that opens first, but it means that it's closes first. It means that at the end of our way, when we join the European Union, the EU countries have to be sure that our institutions are sustainable, there is trust to our institutions, they are functional, and they will remain functional as we become part of the European Union. And that is why the establishment of the commission that involves international experts is limited in time. It has specific timeline, and on some bodies, for example, the bodies of judicial self-government, this selection is a one-time process. So I am very happy that this discussion is taking place. I was listening to it. I was not able to join earlier, but I did listen to the previous panel discussions, and I noted down a couple of various opinions. And I think that we have to think about the prospects, the future prospects, and we have to move towards establishing an independent body, and we should consider this institution as a constantly functional body that ensures integrity, because we're also facing the situation when there is a need to assess the integrity of a person during the period when the person holds a position, be it a position of a judge or a head of in the law enforcement body or another position in the government agency. So the integrity should be assessed not only when the person is appointed, but this assessment mechanism should be in place as the person holds the position. So I am very grateful for this discussion. I'm very grateful for your thoughts, and I'm hoping that further we will also keep discussing it. And finally, the only thing I would like to mention is that there is no specific timeline, so there are no deadlines. We are thinking about how about it as a strategy element, and we need the analytics within our roadmap. So I encourage you to share your thoughts and your positions. Thank you. Thank you, Olha. I would like to pass the mic to Tatiana, and I would like to ask you about the participation of international aspect. What format do you envision? What do you think about the time frame of their work? We have a quite diverse experience and interesting experience of the work of international experts in various commissions. And it's like we have one approach that the international experts have the majority of vote as they take part in the selection of people for the judicial positions, the position of judges. We also consider the law enforcement agencies here, and the customs service and ARMA have also become part of it, and the Agency for Corruption Prevention as well. And in fact, all these models are different. So we have 6 different models in judicial bodies, we have a different model in law enforcement bodies, because the idea is not to only have international expert in the commission. The idea is to have a transparent competition that will ensure that we select best professionals with good reputation and high integrity. And here we have 3 key elements. Who selects? We have international experts and Ukrainian experts, and we would like the quality of Ukrainian experts to be the same as the quality of international experts. Because just by comparing the CV and bias of the people, we see misalignment, and we would like the Ukrainian bodies, the Ukrainian governmental agencies to, well, be more cautious, maybe not cautious, but more diligent when it comes to selecting the representatives, the Ukrainian representatives, because it will improve the quality of the competition. And as the term of international experts comes to an end, there will be Ukrainian experts who catch up, and they will have high level of expertise and trust from the society, which is very important. The publicity of this competition involves the name of this professional, and when we just see the names of some people on the list, they might be good professionals in their fields. Those are very often university representatives, but we would like them to be public as well, so that they have public responsibility in a way as well, responsibility before the Ukrainian society. Then we move on to the procedure of selection, and here all the regulations that we have in these commissions, they are different. So the idea is the same, but each law has its own specific procedural elements. And every time when there's voting in the parliament, we're facing the same thing. We focus on some words, phrases, and paragraphs so that there is some alignment between these procedures. And it's still surprising because it's been a number of these commissions and we have some experience, but there is still this fight for these aligned procedures. And the final point, well, the competition for the constitutional justices have been mentioned, and right now there is the anti-corruption court, and the problem is people. We see that it's as though, well, there is competition, there is an opportunity for people to be selected within this competition. International experts ensure honesty and transparency, and it was supposed to motivate honest professionals to apply because they have a high chance to receive a position and serve their country. However, we see that in a way, the quality of candidates who apply is dropping. And it's a mystery in a way to us, and also a challenge as to how to boost the number and quality of professionals who apply for this competition, because this is all about competition. If we have just 2 people with low integrity applying for the position, no matter what procedures we have in place, no matter what commission is selecting, we will not be able to select a good candidate. And of course, we're moving to the question of terms, the timeline. I don't have the answer to this, and I would just like to say as much as needed for the processes to flow by themselves without additional attention from international partners, civil society organizations, and maybe, well, it's not going to take a year or 2 or 3, it's going to take a couple of cycles. For example, we selected one composition of the High Council of Justice, then we selected the other composition. So one cycle of selection is not enough. We need more. And as the competition to anti-corruption court demonstrated, selecting the judges once is not enough because things happen, the workload increases, so there are new openings, new job opportunities, and we have to keep hiring people to courts and to other bodies. Thank you. Maxim, how would you comment? What is the reason behind dropping the quality of people who apply, and why do so few people apply? There is a very long and a very short response. Well, you have 5 minutes. Then I will present a short response. This is the decreditation of state service, civil service as such. The thing that the civil society representatives do and international partners do, and a lot of other people do that are involved in the reforming of the state sectors. There are 2 sides to its processes. On the one hand, we are countering corruption and we introduce integrity. On the other hand, when we keep fighting this, we discredit the civil service as such, because there is a general tendency to talk badly about state officials, judges, and anyone who has access to the state budgets, because they probably abuse their powers. This is the presumption we have. So basically, a professional who values themselves, who has high income, or who wants to build their career, that kind of professional, I will circle back to the topic of judicial bodies. So that candidates stopped seeing the role of judge as the top of their career, because in their viewpoint, when they apply for the judicial position, they will face with the hate of the society. They will put their private life under scrutiny, and most probably nobody will say thank you to them, because any decision they make and somebody will not be happy with that decision, the judge will probably face criticism for that decision, or putting their private life even under more scrutiny. So I have a simple message today. When we are fighting corruption, when we try to extract this evil from the processes where we are in the middle of together, it's very often it's important to be careful. For example, we see what's happening in the US right now, because they announced the fight with the so-called low integrity of international assistance, and this resulted in the complete shutdown of USAID, because people did not want to delve into the detail. They just chase the holistic messages, and these are the trends. So we will face very complicated future ahead of us, because if the conflict is frozen this year and we will turn back to some pseudo peaceful life, we will have very small window of opportunities to join the European Union, at least for the next 4 to 5 years. And if we don't use this window of opportunity, I'm afraid that our generation can say goodbye to having a successful country in the future. So a simple answer to the question why international experts should take part in these procedures, because one of the first questions that Brussels is asking, including when we travel there within our international advocacy. So our partners, representatives of civil society organizations say, dear friends, there are two things that you have to pay attention to. The first one, the EU accession process will be merit-based, so it should be based on your merit, not just because you want to be part of the EU. And the other thing, everybody is talking about the corruption in Ukraine, and the only way to counter this narrative is to ensure the participation of international partners in the selection process, because thanks to their legitimacy, their participation, they will legitimize the process altogether, and nobody will be able to say that the selection process to a certain court or to high anti-corruption court was not fair if international partners took place in this procedure, if their reputation is good, if their career is good. So that's why we need international experts. And this is a very pragmatic conclusion, and it lies on the following foundation. We should, till the end of this decade, we should follow our ambitions to become the part of the European Union, because this is the only guarantee of our security and the future of our country. If we do not reach that, we will not have any discussion about any future of the judicial bodies in Ukraine. So international partners in the commissions is something that will allow us to ensure the high quality process. And as Ms. Stefanishina mentioned, related to chapter 23 and block 24, that are part of the first cluster of fundamentals, it will open first and it will close last. So in order for us to show that integrity and the fight with corruption is taking place, and we have specific examples of that, for that, it's critically important to have international experts in the commissions. And the last message is that there's a huge difference between corruption and the perception of corruption. And there was a rating of Transparency International of corruption perception, and Ukraine lost one score, dropped down, despite the fact that our neighbors who also have corruption-related issues have higher indicators. So the perception and the corruption are different things. And when we talk about corruption in the international platforms, we create the impression that Ukraine is a highly corrupted state that has no future. So I would like to ask colleagues and everyone around to be more pragmatic about this, because we have a joint goal and we have to do everything to achieve it. Thank you, and thanks, Maxim. And I would like to give the floor to Andriy. Andriy, you were a member of the High Qualification Commission of Judges, and you took part in this competition for the High Anti-Corruption Court, and you dealt with Public Council of International Experts. So how was your experience? What do you think about the role of international experts and whether we managed to achieve transparency and openness of the competition?
I have several roles. I'm a member of the High Qualification Commission of Judges with different consequences. As you know, in the period 2016-2019, there was a mixed experience, so to speak. I was also a member of the commission to select the director of the State Investigation Bureau on behalf of the parliament, hoping that there would also be international experts, who had to be 3 people. But since they had no decisive vote, casting vote, veto right, they just were not delegated. And this was essentially a 6-member commission, 5 against 1, with the result that I think everyone can assess now, especially considering the beginning of the war. And the third experience was the experience being in the commission to select the head of the NACP. I am a Ukrainian, but I was appointed under the international quota, nominated by Ukraine's international partners. And comparing all these experiences, if I may, I will try to answer your question a bit more broadly. First, we speak a lot about sovereignty. Considering the populist trend that exists, there will be more and more statements like this. I am I have quite a different attitude to this, and I urge others to do the same. I urge you to reframe this. A lot of people perceive the participation of Ukraine of international experts as a concession on behalf of Ukraine, sort of concession with everything that we love doing, looking at outside authorities, corruption. But these are not Ukrainian values, as illustrated by Ukrainian humor and satire when. Bribe takers were condemned and made fun of when ignorant people were laughed at as well. I would consider international support to be an additional skill, an additional power up, so to say, that Ukraine receives. This is particularly important, especially during the war, because giving up every new opportunity and every new energy module that you have, so to speak, is a weakness. And Ukraine's situation is that we have to be faster, better than most of our partners who provide this assistance. And we need to do this in a very limited time frame. That is the first thing. And again, you hear a lot of things like foreigners make the decision. No, it is Ukrainian agencies that make the final decision. Yes, it is with participation of foreign delegates, but they act in the limits prescribed by the constitution, prescribed by the law, and that's it. In addition, these foreigners are invited in line with the Ukrainian law. They are invited by Ukrainian agencies. So they are somewhere in between other processes that are decisive. Of course, the participation of international experts is by no means a guarantee. There is no silver bullet here. We cannot say for sure that the person or people who will be selected will not become worse than we expected at the beginning. There are some examples of this. I always remind others, though maybe this does not make me popular, that I was the reporting member on Mr. Knyazyev during selection for the Supreme Court. This was me. And at that time, Judge Knyazyev looked much better than the rest of the candidates for the Cassation Administrative Court. What happened to him during these 7 years? I think that it's a different court that should say this. With the High Anti-Corruption Court, you can also see some examples that not everything is perfect there. There are some internal processes that are not very good. Some judges, I don't want to offend anyone, but they have been observed to show weakness, and we hope they would be stronger in defending their views, their service, and the values that this court is ensuring the standard forming one. And the third problem that we see in connection with all of this is when international experts bring some new, especially when it's like new technologies that are well known across the world, but not here. So there are two other types of populism that emerge here. Regular populism, which you observe when you are part of this commission, and there may be a serious clash of positions. For instance, should there be an open discussion of candidates, as it happened with the NACP competition, as you may have seen, and this goes all the way to things that are called dictating, that are called experiments, and so on. Not everything is simple in those commissions, that's for sure. But there is also professional populism. This is when representatives of the professional environment try to push recipes that are easiest and most comfortable for this environment. A remarkable example for this is IQ tests, when the judicial environment essentially attacks those who hold them. These tests have decades of history. They are used in many countries across the world. In isolated cases, they are used in judicial selection, but they do work. And most importantly, those who understand maths and statistics, they have millions of results which can show that these tests are relevant. But you can see this wave of ideas that they are unnecessary, they offend someone, they do not provide the right picture, and so on. The NACP competition also had a certain cross-section of society. And they showed quite a high level of the intellectual quotient. If this happens in selection for courts, where you have the threshold at the level below average, there are two positions here. During the time when there is a deficit of personnel, it may be okay to recruit people with this lower level, but remember that they are appointed forever. But there is a different approach to turn a blind eye to the problem, although this problem is evident. And if you look at the average score of the judicial core, I think society just shouldn't know this, because there is a big problem here. And the problem here is, well, let me mention a couple more moments about different commissions. HQCJ with PCIe and HQCJ without PCIe during my term are two different organizations. If you know my story, I often was, so to say, on my own when I was there. Yes, there were situations when I found some kind of support. There were not a lot of them, but there were people who wanted at least some progress. And I will say that for 2016, 2017, at least some progress was still progress. So it was important to understand that the progress that existed was important anyway. A very simple example is a family of judges. The HQCJ and PCIe banned a person who had conflict of interest. You can look at a lot of aspects here. You can look at the post-office syndrome of avoiding shaming yourself in front of foreigners and desire to show a good result. But that's how it was. But then a different member of the very same family with the same conflict of interest, and I was really mad about this. Another member of this family came to his regular qualification assessment just 2 or 3 weeks before that. And the same composition of HQCJ got together for a meeting without the Public Council of International Experts and found him to meet the criteria of integrity and professional ethics. But we speak about the same property, the same story, the same false declarations, and so on. This leads us to an interesting conclusion. On the one hand, sovereignty is also about cultural differences, but in the Ukrainian tradition, we never respected bribe takers and their accomplices, those who try to encroach on freedoms and rights. But for some reason, in the work of Ukrainian commissions, cultural peculiarities are seen as something not very good. International experts are good because they are able to disregard these things. They don't have any negative or positive prejudices. They don't have friends in the Ukrainian authorities. They don't have leverage that can be used against them. And if they see this situation, they make their decisions based on doubts that arise. So if we follow through with this, what is our goal? Isolated points of normalcy in the existing system, or is our goal to establish new standards, to establish a stable, normal environment? When there is a stable, normal environment, you see a lot more people joining it because you know that you will work with good people of high integrity. I have to remind you of the time. I feel that I'm not talking a lot more than other colleagues. I am wrapping up. I am thankful to you. Okay, maybe the participants would like to say something. Maybe there are questions from the room. This is Darka Tижня, Inna Vdarnikova. Andrei, I have two brief questions. You said very aptly that high anti-corruption court sometimes shows weaknesses, but the problem is that all institutions in judicial governance show weaknesses. The HCJ, the HQCJ, the Supreme Court, the High Anti-Corruption Court. And there is this general idea that our judicial system doesn't have its own agency, and the driver of the reform is the public now, which does offer very revolutionary measures sometimes. And the judiciary says it's enough to check us and reform us. I want to ask you, as an expert, why did this happen? Agency will not start until our judiciary has it, until it acquires it. I also have a question to Ms. Stefanishina, if she is still with us. I would like to hear a bit more specifics. She said that there are no specific deadlines for purely Ukrainian selection commissions, but European speakers and the public say that this is a very long process for several tenures. So I want to find out if some commissions already lose their mandate in 2025. Will there be new international experts that will be selected? I want to hear something more specific about this. Thank you. I would like to invite Ms. Stefanishina to speak first, if I may, and thank you for your question. Is Ms. Stefanishina with us or not? She is not, then Mr. Gazlov, over to you. I will answer just my question, if I may. People are generally weak. This is true. There are a lot of influences in life, a lot of temptations and a lot of threats. And they exist today. In order to prevent this, at least outside the scope of force majeure that we have now, or any other incident like this terrifying war, it is institutions that should prevent their weakness. It is accountability and, of course, internal control. Institutionally, we have quite a lot of guarantees of judicial independence. However, it all depends on how people use them and how other people try to influence judges, and whether judges are capable of resisting those influences. The judiciary as the present HQCJ members will surely agree since they have seen those tests. We have one big problem in the judiciary because a very common trait of character of judges is the low ability to stand up for their opinion, unfortunately. That is why the selection, if I speak about the point of bifurcation, has to have quite a significant number of people, at least 15 to 20%, that are very difficult to influence. If these people maintain their integrity, you cannot really affect them, and they will become internal watchdogs of their institutions in the judiciary. Without the NABU, without the NACP, other colleagues will look at them. Of course, they will perceive this like, what do you need from me? But they will still have to look at this. They will still have to make sure that they rely on those colleagues' opinions. And the work of commissions depends on this a lot as well. The colleagues said that we have different procedures in different commissions, and there are some risks here because we may decrease the number of methods of assessment, but maybe we should implement a single procedure and unified methods of assessment, or at least the core procedures or different assessments in different agencies. This can become an additional issue perhaps, but it is very important that we have the same core, I feel, because if I look at my experience, the HQCJ carefully studied everything that is possible to study, including psychological tests and IQ tests. And as for these psychological and IQ tests, they're zero weight in the final decision that we had in 2016 to 2019. Thankfully, in the current situation, the law is different and they have to be taken into account. That's one thing that I wanted to say. The State Bureau of Investigation, the Commission for the SBI didn't even want to approach the NABU to get information from the candidates about their relatives, other family ties. The Commission didn't want to look at this at all. The NACP Commission studied everything possible. Everything that could be imagined. Any choice can turn out a disappointment over time. There are sometimes hidden risks that may not necessarily be disclosed even in a very advanced psychological test. But at least the NACP Commission did everything possible to select the best candidate among those who applied. You could see that at a certain point the votes of the Commission were divided. So we found a compromise that both parties found acceptable. So that's the thing. And unfortunately, this is one of the problems with the competitive selection, that if there is no casting vote of international experts, there is almost always a clash, there is almost always a conflict. And there was a big example in the competitive recruitment for SAPO. This was a really major problem when there were people representing Ukraine who didn't believe in this path at all. And I will speak about a specific recipe again.
So I will speak about the institutional capacity. We need to reach the critical mass of people selected based on new procedures and having even more people than needed, because people are in deficiency. People are a good that spoils fast. I can frame it this way, because the feeling of power, the feeling of opportunities all add to spoiling this good, especially when a person talks to the powerful and the rich people, right? And accountability is important as well. It has been introduced on a large scale here, and accountability in front of ourselves as well, and accountability in courts, accountability in front of the public, and accountability, well, formalized accountability, so declarations, regular assessments, that should also be taken place, but of course taken into account the principles of changing the judges. So of course the evolution is another aspect, because if we compare the courts now to what we had in 2013 or even in early aughts, and I do have this experience, even with the problems that we are facing right now, the situation is unrecognizable. The institutions have changed a lot. Thank you. There was another question, right? Okay, Mr. Asier, would you like to comment as well? Would you like to add something?
Thank you so much. To make a couple of comments. First of all, following also with one of the comments that was made by our ambassador at the very beginning, corruption is not only a situation that occurs, let's say, in the judiciary in Ukraine. I mean, it happened in other countries as well. Some of our members already had to go through similar processes. The judiciary had to be vetted, reorganized in some cases. And in particular, in my country, for instance, I mean, we changed from a regime to a democratic system in the 70s. In the 80s, we had to go through a different type of judicial reform, and from time to time, we are still discussing about it. We are, let's say, more than 40 years after the approval of the new constitution and the new democratic system. Meaning, there are experiences before that can be, from which they can be learned, but you also need to consider that you also have gone through this for the last 10 years. So you have a number of lessons that have been learned already, and we cannot simply reinvent the wheel all the time. So there are different systems. They work in different environments and they respond to different needs. But the reality is that whenever there is a new selection process that needs to be approved in Ukraine, we have to go through a number of discussions, a number of negotiations that takes time. And sometimes we already have the response there. If the aim is to get into the EU in the next years, and 3-6 years, you cannot reach the EU with internationals participating in selection processes. You need to tell the EU that you are a country that can select the judges and the high-level officials without the participation of internationals. And this is something that you also need to think about. So now there are a number of processes that have to move forward. There are new selection processes that will have to be approved. Let's focus on how to move forward in the future, how to learn from this. We don't need to have a deadline, let's say, in each process, but the reality is that we need to start thinking about how to make sustainable those selection processes without the participation of internationals. And we can start with the debate today, with that debate today. We don't need an answer in the next months, but we need to start thinking about it. Second, Vice Prime Minister and the Minister of Justice, Olga Stefanishyna, has mentioned a number of commissions that have stopped the work because of the lack of support from the US. I mean, we have been working on it. Bravo Justice, our flagship project on judicial reform, is already supporting the Ethics Council, that is supporting the High Council of Justice, as well as the advisory group of experts that is supporting the Constitutional Court of Ukraine to ensure that both commissions are really working and that the reforms are not stopped. We are also thinking about how to support the selection commission of the High Qualification Commission of Judges, either alone or with other donors. We are talking already with the Netherlands, with Germany, with UK. There are a number of donors that they can really, and they are waiting to jump and to support these processes. The US is not there, it's not going to be there for the next couple of months for sure, but these processes, they cannot stop. We are ready to support, and the challenge is big, but I'm sure that we will manage and we will respond together and that ensure that these commissions are working properly. Thank you.
Дуже вам дякую. Можливо,
Thank you. Thank you. Okay, we have another comment. I would just like to comment and say that this discussion, I think everybody will agree that international representatives are needed, but I would like to respond to what Olga Stefanishina said, that we should demonstrate to the European Union before accessing that we are able to update the system by ourselves. And I have not heard such requirements to Ukraine. Maybe the participants of the panel would comment whether there are such requirements, but in my opinion, I would simplify to the analogy that the judicial system is the car that we're pushing and international experts are helping us. And if we remove international experts, this car will just stop because it doesn't have enough inertia. So this is the simple analogy I wanted to provide. And maybe it will even roll back. So I personally do not see any problem when it comes to Ukraine joining the EU and there is international experts participating. If it gives the result, they should stay there. If we remove that to just demonstrate that we can update the system by ourselves, the system will probably roll back to the state it used to be in before. Thank you. Any comments from anyone? I will just quickly summarize very briefly. Mr. Asier just said that there is this expectation to prove our capacity to the capacity of our institutions to be in line with the European Union rules, and this is the hardest challenge that we have, the lack of a quality criterion that will allow us to assess the institutions and say that they are in line with European standards, with the rule of law standards. If it was possible, our way would have been simpler, and unfortunately our way when it comes to these requirements, our way is difficult, and with the lack of simple test to demonstrate that we have the rule of law, that we have functional institutions, unfortunately, we have to take this challenging way and prove that at some point that our judicial system is in line with European standards, is in line with Copenhagen criteria, etc., to prove that we can assess and be part of the European Union. And as Mr. Sears said, we have to think about it, but we also have a lot of urgent issues, a lot of pressing issues that we have to solve right away. We need a lot of professionals, high integrity professionals in our system. This is something that we should focus on as well. Thank you. Thank you to everyone. Thank you to all the panelists who have joined us today. And I would like to give the floor to Natalia. Thank you, Oleg. And I would like to Mikhailo to join us, to join me. But dear panelists, if you're comfortable, you can stay where you are. And we are moving to the closing part of our event. And I would just like to say that we can... there is a book by Leonid Kuchma, Ukraine is not Russia, and we can add another chapter to it to illustrate that we have these discussions that because up until 2013, I don't think we could imagine the discussion between the representatives of the public, representatives of the judicial self-government, with the judges of the Supreme Court, with the vice prime minister. I don't think that this could have been possible before 2013. I think we had a very good exchange of thought. We had high representation today, and this is wonderful. If we compare, in 2017, in November, we had a similar discussion when the first stage of the selection to the Supreme Court took place. And it was a conversation, well, on the one hand, PIC, and on the other hand, there were all the enemies. And now the format is very different. We have a very constructive and frank, open discussion. And I think this is a huge leap, not even a step, but a leap ahead. But Mihailo, so are we doing enough? Despite my happy reflections, are we doing enough to have just courts? Well, what is the difference between a professional moderator? How we can identify a professional moderator is the ability to keep us engaged, to follow the timeline as far as possible, and to go back, to circle back to the key question of the discussion. So, dear colleagues, I don't know whether I have the final answer to this question, but because I think for sure there's a lot to do. And we discussed a lot of elements of it during these 3 panels. I don't think we will complete all of it. And I think that this discussion has highlighted what we should focus on and gave us the ground for thought. And thank you to everyone who stayed till the very end with us, considering the fact that the discussions were not simple. And I think that overall, we did have a good discussion. This is good. This is the feedback I got also. And, this is what we were trying to do. This is the way we try to organize these panel discussions, so that we have different sides, we had different thoughts, and we heard it today, so that we were trying to find the good arguments in these discussions. And thank you to everyone for participating in the discussions. And I am very happy that we had some international representation here. And I think we have a lot to talk about when it comes to formats, models, terms, timelines, etc. But I think these are the mechanical parts. And when it comes to, one thing, we keep thinking about it all the time. Will we manage to jump in this window of opportunities to use it and join the EU? If we look at the fact that at the moment of accession, we have to be perfect and we have to complete the judicial reform, I don't think we will manage to achieve that in 3 to 6 years. Let's be realistic. We've been doing it for 10 years already, and we still need a lot to achieve. At the same time, should we then say, should we decline one or the other? I think that there is a recipe. And I would like to advertise another product, the paper that you have in your blue folders, the paper on international commissions. And this information is also available online, so you can find these documents online. So there's a mechanism that was applied in both Bulgaria and Romania, 12 and 15 years in both countries respectively. There was this special period, so that they had similar situation. It was clear that their system was not perfectly ready in terms of rule of law in particular, so they introduced a special mechanism for 12 and 15 years that have been closed just recently. During this period, the special conditions were still in place, and I think the situation will be that we will not be able to complete everything until this window of opportunities will be closing. So this might be a solution for us. And looking at good news, we have these creative solutions, and in particular, we have the understanding of what is not working. We have an understanding what is working, and we talked about it today, and we talked extensively about it. So we can complete a puzzle from all these parts, and I think we have enough IQ, people with good IQ. We have enough hands, maybe not maybe there is some lack of specialized personnel in some competitions, but in this room we have a lot of smart people, and we have people with high IQ to complete these puzzles, to have a high integrity, to present high integrity at competitions. So thank you to the facilitators, thank you to panelists, thank you to everyone who helped to organize this meeting. Thank you to the wonderful team of the DEJURE Foundation. I'm very grateful to all of you, and I'm specifically grateful to the Armed Forces of Ukraine, because it is thanks to them that we are able to not only freely discuss these, but to discuss how we can join the European Union in 3 to 6 years having the rule of law. It will not be possible without the Armed Forces of Ukraine. Thank you to everyone. Yes, I would like to say thank you to everyone who stayed with us till the end. Thank you to all of you who joined us online. And till the end, I would like to ask the operators of the screen to present the QR code. And you can follow the QR code to donate, to purchase 4 drones for the battalion of Da Vinci, Wolves of Da Vinci. I think this will be wonderful, a wonderful final stage of this fruitful discussion to join the fundraiser. And we would like to invite you to join the informal part and just network and talk to each other over tea, coffee, and some snacks. So thank you and have a good evening.